Can't hear you guys. I don't know.
Right again. Can you hear us now, Commissioner Bennett?
Yes, maybe it's the 10 degrees. It's over here. It's frozen all of the cyber link.
Nice. Okay, we're gonna do the roll call. It would be good if we could get somebody from IT to come and help, because we want to make sure to get Commissioner Bennett, mic up also.
Commissioner Bennett, can you hear me now?
Yes,
Okay.
loud and clear, actually. Thank you.
Okay. So you are present?
Somewhat, yes.
Okay. Commissioner Porter,
Present.
Commissioner Thompson,
Present.
Commissioner Warren,
Present.
Vice Chair Lazo,
Present.
Chair Halova.
Present. Thank you for the roll call. So we're pleased to be here at the December 4th, 2024 meeting. Commissioner Thompson has volunteered to lead us in the land acknowledgement, which I believe, yeah, is going to be put up. Thank you.
Thank you, Chair Halova. I'm honored. Indigenous tribes and bands have been with the lands that we inhabit today throughout Oregon and the Northwest since time immemorial and continue to be a vibrant part of Oregon today. We'd like to express our respect to the first peoples of this land, the 9 federally recognized tribes of Oregon: Burns Paiute Tribe, Confederated Tribes of Coos, Lower Umpqua, and Siuslaw Indians, Confederated Tribes of Grand Ronde, Confederated Tribes of Siletz Indians, Confederated Tribes of the Umatilla Indian Reservation, Confederated Tribes of the Warm Springs Reservation, Coquille Indian Tribe, Cow Creek Band of the Umpqua Tribe of Indians, and the Klamath Tribes. It is important that we recognize and honor the ongoing legal and spiritual relationship between the land, plants, animals, and people indigenous to this place we now call Oregon. The interconnectedness of the people, the land, and the natural environment cannot be overstated. The health of one is necessary for the health of all. We recognize the pre-existing and continued sovereignty of the 9 federally recognized tribes who have ties to this place. We thank them for continuing to share their traditional ecological knowledge and perspective on how we might care for one another and the land so that it can take care of us. We commit to engaging in a respectful and successful partnership as stewards of these lands. And as we are obliged by state law and policy, we will continue to uphold government-to-government relations to advance strong governance outcomes, supporting of tribal self-determination and sovereignty. Thank you, Madam Chair.
Every time we read the land acknowledgement since the time we started reading it, I feel like more confident with the work of the department and all the things that we're doing to fulfill the intent and spirit of this land acknowledgement. So I just thought, for me, and you've probably seen, it just gets me really excited about that. So thank you. So commissioners, I want to remind you to please complete your agenda scorecard, which is found in your binder before you leave the meeting tomorrow. The feedback about meeting logistics and process is very helpful to staff. And so with that, we're now going to approve the agenda. Are there any proposed changes to the agenda? And or Director Bateman, do you have anything to add?
Thank you, Madam Chair. Also getting used to the new microphone, so let me know if you can hear me too much or not very much at all. I don't have anything to change on the agenda. I had a couple of things to note, though. It's a very heavy agenda over the next 2 days, very substantive work. And so you'll note that we did not schedule a field trip for this meeting. And we've asked Denise to put a couple of extra or longer breaks into the agenda. So, and we've also given you badges. So if at any time you feel like you need to do a quick walk around the block, it's cold out there, take a breath of fresh air or poke your nose out the doors, you have faster ways to get back in again. But we wanted you to have a chance to stretch your legs. Feel free, please, at any time during the meeting to, if you need to stand at your space or walk around the room a little bit, do whatever you need to do to kind of stay engaged and energized. We know it's a heavy schedule. And then also, please don't run off on Friday when we're done. If you could stay a little bit extra, we have staff available to help you upgrade phones and also take care of any annual training that still needs to be done through the work platform. So we've got folks here to help you. If you would stick around for a couple minutes, we can help get those things checked off for you. And finally, it's I think it's the next to last page of the agenda. Chair, you signaled to us last time that we had garbled a little bit the commissioners and their terms, their dates. We've got that fixed now. So I just wanted to let you know we took another look. You were right, I was wrong, and it's been fixed now. So thank you very much.
I think with that, we're gonna adopt the agenda and then do introductions. So commissioners, maybe we'll start off with Commissioner Bennett. Please introduce yourself and your region of representation. We're gonna go into more detail with commissioner updates tomorrow. So tomorrow we're gonna actually say like what's going on in your region and ask those questions. But today, yeah, good. Just say your name and the region you represent. Commissioner Bennett.
Mark Bennett, Eastern Oregon.
Barbara Boyer, Willamette Valley. Ellen Porter, Southern Oregon.
Leanna Thompson, Coastal Commissioner.
Stuart Warren, Southern Willamette Valley.
Alan Lazo, appointed from the Portland metropolitan area.
And Anjali Halova from the Portland Metro.
If I could get you to speak just a little bit closer to the microphones. They're having trouble hearing us on YouTube.
Sorry about that.
That's
I
okay.
instructed everybody to pull it far away.
I know, we did adjust the volume, so hopefully
okay.
that helps.
There we go. Okay, we got new microphones today, which we're really excited about, but we're in the process of testing how close or far it has to be from each individual. So thank you for that feedback. And now we're going to ask the DLCD staff and guests to introduce themselves that are in the room. I was thinking maybe we'll start there.
Good morning, John Dunsmore, Network Administrator. Thank you for your patience while we get used to this new audio system. I will ask that you do need to speak closer to the mic. What you hear in the room and what you hear online are different. This does not project very well online on Zoom or YouTube, and this is much better. So thank you.
Thank you.
Hey, Ingrid Cordell, Housing Division Admin Support.
Denise Johnson, Commission Assistant.
Kirsten Green, Deputy Director and Travel Liaison.
Steve Shipsey, Counsel to the Commission.
And Brenda Bateman, DLCD Director.
Nice. Thank you. So now we're going to begin with agenda item number 3, which is the director's report. I'd like to invite Director Bateman to give us an update on the Department of Land Conservation and Development.
Thank you, Chair. Just quick time check here. Okay. Again, my name is Brenda Bateman. I'm the DLCD director. I'm pleased to bring you the director's report this morning. There's a lot in the report, and so I'll leave most of that for you to read, but I do have some updates and some pieces that I wanted to highlight and dive perhaps a little bit deeper into. First, just personally, I wanted to start with a few moments of thank you. I recently had an opportunity to travel to Australia to visit with my daughter who was studying there. I wanted to thank the commission and our staff, senior staff, and actually all of our staff for doing a fantastic job with the agency, moving it forward while I was gone. It was a pleasure to be able to go and to have that time. I took a lot of notes while I was gone. I know I was on vacation, but I still took notes. There was a lot to see and a lot to learn. And one thing that really struck me that I wanted to bring back and share with you all was the land acknowledgement that was pervasive everywhere from the time each airplane touched down in each place to each public space that we went into to each event that we attended. There were signs, there were announcements, you couldn't miss it. And it was very simple, and it was really quite neutral in its statement, which was, you are entering the traditional lands of fill in the blank. We're here to respect their elders, past, present, and emerging, period. And it was everywhere. It was so striking to me that it's so ingrained in a culture, and it's so available so that you have the information about what land you're entering. That just struck me as something that was very powerful that I wanted to share with everyone. So many different ways of doing things around the world and so many ways to learn. So I also brought back with me some Vegemite. If anyone would like to try some, I put some out on the counter in the kitchen and didn't get many takers. So I thought I'd bring it down here. A very thin layer on toast or crackers is the way to go with this, but I find it enjoyable. I hope you do too. So I just wanted to share that with you this morning. A little bit on the director's report. I wanted to jump in straight into the new hires. We continue to grow and learn and grow our talent here at the agency. I have a couple of pairs of folks to introduce to you. I'm not sure if we have folks online. We definitely have a couple of our new folks in the room with us. And so I'll just call a couple names, and if you're here in the room, you can come forward, or if you're online, we'd love to hear from you. But the first pair of folks that I wanted to bring to your attention are two brand new managers in our operations division and our administrative services division. And that's Colin Lancaster, who's our chief information officer, and Joshua Tanner, or JT, who is our chief data officer. We're particularly excited about these two as they're joining our agency for the first time, but they're also in brand new positions. And these were positions we got during the last long legislative session because of a recognition that we really need to get our data governance, data management, and those systems in order. So we've got two folks who have recently joined us. I don't see either in the room today. That's okay. But those two really walked in the door at the same time. And so they are already a fabulous duo for us. And then the next two that I wanted to call forward just briefly with maybe your name, where you've come from, and what you'll be doing for us are two people who have introduced themselves already. And they are our administrative help in, sorry about that, the programs area and the operations area, supporting directly our deputies, Kirsten and Josh. So please come forward to the microphones. Just a brief introduction of your names, where you've come from, and what you'll be doing, or what you're already doing. Thank you.
Oh, hi, I'm Jess Miller. I am the Executive Support Assist Specialist for the Director's Office and for programs. I am from everywhere. I'm an Air Force brat. Most recently, I moved from Portland, Oregon, where I spent 14 years. I just moved to Salem, and I'll be helping with commission. I'll be helping with LOAC. I'll be helping make sure things are printed, make sure documents are edited. I'll help make sure anything you need. Just let me know.
I'm Tamara Lindy. I'm the Executive Support Specialist for the Administrative Support Services Division. And so I'll be helping with the budget office and with our data management and IT. And so that's kind of my role, helping them out as much as I can. And I'm originally from Nevada, Arizona area, and now live in Oregon. I have a master's in geology. So I'm hoping to bring a lot of that information for GIS information to my team. So
Fantastic. Thank you
excited to be here.
both. We have folks on the screen. Colin. Okay, that's okay. We'll keep going. I see Lauren on the screen, and we'll have Joel come forward as well. The next pair that I wanted to introduce to you is the standing up of the new HAPO team. Finally, we have a manager in place, and we've already started hiring some staff, more on their way. But let's turn it over to Joel Madsen to introduce himself and his team to you.
Thank you so much, Director Bateman, Chair Holliva, Vice Chair Lazo, and Commissioners. It's great to be here. My name is Joel Madsen. I'm in week 5 of the new role here at DLCD as the Housing Accountability and Production Office Manager. And I come to this work with my past and my passion of helping people find safe, stable, affordable places to call home. And I'm really excited for the housing initiatives within DLCD and more broadly across the state, and just ecstatic to be here leading the efforts of the Housing Accountability and Production Office. My most recent role, I worked within a regional public housing authority, and really enjoyed some of the work that we did on statewide policy advocacy. This is certainly an initiative that we were paying close attention to. So again, just excited to be on this side and happy to be in the role. Lauren Drayson is one of our newest teammates, and so I'll hand it over to her to introduce herself.
Hi, good morning, everybody. Hopefully you can hear me.
Yes.
I'm Lauren Dressen. I am the new one-stop coordinator. I am on day 4 with DLCD. Really excited to be here, and really excited to look at housing from a different lens. I previously came from Oregon Housing Community Services Department, where I was there for 3.5 years, most recently overseeing the rebuilding of homes lost in the 2020 wildfires. So have definitely run into some of the land use and planning from that side, but really excited to dig in on this side.
Fantastic. Thank you both. And I see that we've been joined by Colin. I want to swing back around again for Colin Lancaster to introduce himself.
Morning. My name is Colin Lancaster. I'm the Chief Information Officer here at the Department of Land Conservation and Development. Before I came from Energy, the Department of Energy, as the Chief Information Officer. I have a history of working in technology. I am a full stack engineer and have been a product manager in the private sector as well. I'm thrilled to be here serving the mission and serving you all. I'm pretty approachable, so please feel free to ask me any questions. If you have any questions about our technology stack or any suggestions, I'm here to serve. So thank you very much.
Thank you. I understand JT, who's our Chief Data Officer, is home with a sick child today, so we'll catch him later. Thank you so much, Colin. So the 6 folks that I've just brought to your attention are all joining us from outside the agency. We're very excited that they're bringing with them a wide experience and some different ways of doing things. Last meeting, as you might recall, we introduced a lot of folks to you who were being internally promoted. And so that created a cascade of dominoes, right? Opening their positions, and we have many recruitments underway as a result of that now. And so those are all noted in this this report, and I won't necessarily spell those out for you, but there's a lot of recruitment underway, and we'll have much more to share with you over the next several meetings. By way of a reminder, there's an org chart in the back of your report that can help you keep track of these roles as we fill them. So just quickly moving through the director's report, that next section, that next page is all about the governor's expectations. We talked through many of those last time. Not much has changed there, but I did want to point out in the last row of that table, there is underway a 360-degree review of the director. That was actually conducted for us by Gallup poll in November. Hopefully all of you in the room received an invitation to weigh in on your observations. Went to commission all staff, and then many of our external partners as well. And we don't have results back yet. I heard the participation rate was pretty decent. So I'm looking forward to bringing probably to a future executive session the results of those, and Gallup and possibly someone from DAS would actually be the ones to present that to you so that you have more information about how that went. A couple of other things that I wanted to note for you, sort of in the middle of page 3 thereabouts, legislative and budget updates. I think you're probably all aware that the governor released governor's budget this past Monday with a press release and some materials. And so we have gotten that. Those are released at a high level, and then usually over the next several days, our chief financial officer gets more detailed information and gets a chance to get down into the details a little bit more. And so we actually have a briefing planned for you in January that is much more detailed on the exact FTEs, the comparing today versus in the future proposal. I just wanted to note at a high level, this is a governor's budget, and so there's many months to go still before we have certainty about what we'll actually get in our budget. But this is a proposed budget that will be taken into the legislature. And I cut my teeth on legislative and budget work in the 2008-2009 legislative session. And so my mantra has always been a proposed budget without cuts is an excellent budget. This is an excellent budget for us. So good starting spot. And there was more. So no cuts proposed. And then on top of that, the governor did carry forward the 1% request that we submitted. You'll recall we were invited to ask for 1% more of our current budget. And that involves a budget package that would make whole 5 of our FTE that currently are not fully funded. We've been operating, trying to quilt things together for a long time now. And so that support was signaled and is in the governor's budget, for which I'm really pleased. And then there was another piece there where we have ongoing grant funds, but no dollars to administer the grants. We asked for a little bit of a transfer there. Can we take some grant funds and put them towards the operations, towards the administration of the program itself? And that we also got a nod. And then further, there are 6 additional budget packages in there pointed at our housing and our HAPO work. And those budget packages were co-developed with the governor's office. So it's a nice solid budget for us. We'll have more details for you in January, but I wanted to let you know, and this is always true, when the governor's budget comes out, we support the governor's budget, and you do too. Let's see. On that note, let's see. Okay, so we'll leave the rest of the detail for January, and Aurora and Brandy Nichols will be the ones bringing you that analysis. Let's see, other pieces that I wanted to point out to you. We haven't talked about it very much in this venue because it's not really our portfolio, but there's a lot going on in the realm of FEMA, Federal Emergency Management, and recent requirements that they have presented to our local partners, cities and counties, in order for those local jurisdictions to stay in compliance or to be in compliance with the National Flood Insurance Program. So that is something that's coming from the federal level, from FEMA, and going to our local partners. And there's really very little role for the state to play in there, except for information as we get it, passing it along, and trying wherever we can to provide technical assistance to our local partners in this space. I believe it was 2 days ago, we put together a 1-pager and sent it out to our listserv for folks who are on our floodplain and our FEMA lists. It occurred to me this morning that you're probably not on those lists. So I wanted to let everybody know who's interested. If you go on our website and you search for it's PICM, PICM, and it's that stands for pre-implementation compliance measures. all these acronyms. PICM, State Agency Assistance. There's a one pager that we've put up there, helping folks find some of the resources they may need in order to get into compliance here. We partnered with a number of other state agencies and received a lot of really good links and resources, in particular from Fish and Wildlife, who have said, here are some GIS resources and some things that already exist that might be helpful to you. There are links up there from Department of State Lands because they're responsible for the state wetland inventory. And then we have some links up there too. There's a frequently asked questions and some other pieces that might be helpful. So it's a little bit of a strange and awkward relationship here, but the state agencies are trying to provide as much information and support as they can to local jurisdictions who each need to make a decision on their own for how and whether they're going to comply with these new FEMA requirements. So I did actually print out the one pager that's up on our website if all of you want to see it, but that's kind of going on in the background and parallel to much of the other work we're doing here at the department. Let's see, the last piece that I wanted to note was another FEMA related item. So as you may remember, the department is responsible with its partners for writing the natural hazards mitigation plan on a regular basis and presenting that through Office of Emergency Management to FEMA. This is a really important document because it needs to be updated and it needs to be in place in order for the state of Oregon and its jurisdictions to be eligible for federal assistance should natural disaster or should disaster strike, and we need to ask for federal dollars. If this isn't in place, then we're not well positioned to receive any federal assistance. So we are in a phase right now where we are updating the natural hazards mitigation plan. Many of our state agencies are writing and sending chapters in for us. We don't do this by ourselves. And as you can imagine, many of the natural resource agencies in particular have something to say about fire, flood, drought, ice, tsunami, landslides. There's 5 others that I can never remember, but they're good chapters and good analysis that's coming in. We'll be seeing those over the next week or so. And then we'll move into a time of public comment where state agencies can comment on each other's chapters, but the public can also read, review, and comment. And so that public opportunity for comment will be open here shortly and open through the end of January. So it's a pretty big deal. And it's something that our technical staff has been hard at work on for quite some time now. The last piece of this report that I wanted to bring to your attention, I think, is, let's see, we've just we've just awarded some transportation grants through our transportation and growth management program. And so those links are there in your folders. You can click on each award and you can see what it will entail. And then we have just closed an award window or an application window under our new community green infrastructure program that closed a couple of days ago, and we're in review mode now. I understand we received 67 successful applications, and that they're really creative and they're really innovative in this space. And they focused on everything from green infrastructure projects to economic development projects, native seed banks, native plant nurseries, green infrastructure master plans. And there are a lot of innovative pieces in there. So I'm excited to hear more about what we received and what we'll be moving forward. I think with that, I will stop and allow you to see the rest of the director's report, but please let me know if you have any questions.
Thank you, Director Reitman. I wanted to see if the commissioners had any questions on the director's report. Commissioner Porter.
Chair, just a quick question. How do folks learn about the available grants? Where can they access like the applications and what's being potentially awarded?
In terms of the results, the outcomes of the community green infrastructure grants, or just generally?
Just generally. I mean, initially I was interested in the transportation grants, but I mean, if a community is interested in it or somebody, how do they find what's available?
Thank you, Commissioner. We have a couple of ways that folks can find out about those. Of course, our staff's always available to answer questions, but we also have our web pages that we have announcing grant opportunities, and we have a listserv that goes out under our Gov Delivery platform. But that is assuming that folks have already signed up for the issue areas that they have interest in. I know sometimes those get lost because there's so many that go out, because we're using that platform to not only announce our grant opportunities, but also rulemaking and other major announcements of the agency. But we do try to do both an outreach and a passive, folks are looking for it. They can find it on our website type of technique.
Is on our website, is it like one page with all the grants from the various areas? Because that would be kind of awesome to just have like what grants, and like anybody could just go there at any time, and even putting like past grants would, I think, would be good. So I don't know if we have that.
I don't know, actually. I should double check whether it's all in one spot or whether it's by subject. But I'm happy to look that up.
And I was going to say, up until I guess this year, we didn't have a real social media presence, and so now we definitely have one on LinkedIn. I don't know if we have any on any other forms, but I'm really excited about the LinkedIn. For folks that know me, I'm on LinkedIn a lot. So it's nice to see that. And then that allows the ability for those of us who are on that platform to share it around. And I feel like that's going to reach a different audience than the other more traditional forms. So I think
Thank
that's
you for the reminder.
Yeah. Commissioner Bennett.
Thank you, Chair. A shout out on this very topic goes to Sadie Carney. She had realized that there weren't a lot of applications coming in from Eastern Oregon regarding the green grant. And so I helped a little bit making sure that the cities, I just distributed it. It was a good outreach for me to get connected, and also, but I just think Sadie went above and beyond for the staff. So we need to always commend great work.
Thank you, Sadie. Any other commissioners with questions, comments? I'm a big fan. I'm the one that made sure we have this org chart here always. I think it's really great for us to actually see the names of the staff, but it also helps orient, I think, when we look at an item to be like, okay, this is the team that's sort of being supported by who. And so I would highly encourage everyone to check out the org chart. Okay. Wow. Nice. Running a little bit early. So with that comes the conclusion of item number 3, which was the director's report. Next, we're going to hear from Gordon Howard on item number 4, Farm and Forest Modernization Rulemaking Decision. So and for this item 4, I just wanted to kind of go over the description. So the commission will deliberate and consider adoption of rules amending provisions for protection of farm and forest land. And the purpose of this agenda item is for staff to brief the commission on the draft farm and forest lands amendments. And the agenda item is an opportunity for commissioners to discuss the recommendations and adopt rule amendments. Public testimony will not be accepted for this item as the public testimony time period has closed. With that, Gordon, please introduce your team.
Thank you, Chair Halova and Commission. Gordon Howard, Community Services Division Manager. This morning we have, I've introduced Hillary Foote, who is our Farm and Forest Specialist, to discuss the rules that are before you. These are the first phase of, I think, of a long-term program that we began with the 50th anniversary of the program in 2023 to take a comprehensive look at one of the key linchpins of that program, which is the protection of our farm and forest economy on farm and forest lands. This rulemaking you're seeing before you today, or proposed rules, are really the first phase of hopefully a long-term process to look at those issues and rules and other matters that regarding our farm and forest lands in the state. So at this point, I'll turn it over to Hillary to talk about the specifics.
Thank you, Gordon. So good morning, Chair Halova, Vice Chair Labo, commissioners. So I am Hillary Foote, and I'm the Farm and Forest Specialist for the Department of Land Conservation and Development. And the objective of the meeting this morning is for the commission to vote on adopting rule amendments related to the Farm and Forest Conservation Program. So there are a variety of materials that have been included in your packets today to support your discussions. And I wanted to quickly touch on a couple of those things. So attachment A to the staff report is a clean version of the full set of rules with the proposed amendments integrated into it. So this is the attachment to reference in a motion or decision. But because it's the full set of rules, it's a little bit difficult to find the changes in that. And so we've also included an attachment F, which is a quick reference guide that just has the proposed changes in it. There is also a copy of the notice, a copy of the Rulemaking Advisory Committee membership list. There is a copy of the charge in the packet. And in response to Commissioner Porter's request from the September hearing, there is an attachment E, which is a memorandum that contains a deep dive and in-depth discussion of the cases that were reviewed to support the language proposals related to the codification of case law items. So that memo talks about those cases, it summarizes them and contains quotes that a lot of the language we're talking about was based on. And I did want to convey that that memorandum was reviewed by our Department of Justice Contract Counsel, both Stephen and Sarah. The packet also contains written public comment received since our last hearing. So there were over 100 public comment letters that were submitted. Public comment letters were on a variety of topics, some of which were related to the rulemaking proposal and some of which are on other topics. So comments related to the rulemaking proposal, so themes in those comments are addressed in the staff report in the appropriate sections. Comment on this rulemaking is closed. It closed on October 16th. So this morning there will be no additional public testimony. Instead, this morning, staff is going to be providing another overview of the rulemaking proposal, and Gordon and I are available to answer any questions that the commissioners may have to support your discussions on the proposal. I'm sorry, my forward button is not working. Thank you. So I thought we'd start again this morning by reviewing the process that led to this point today. So I'm actually going to start a year before the timeline shown on the slide. The slide shows the timeline for this rulemaking throughout 2024. But the start of the Farm and Forest Modernization Program really began in 2022. And this is a program that was initiated in response to a volume of public comment that the commission received that essentially identified a need to update certain aspects of the conservation program. So in response to public comment received throughout the first part of 2023, staff had a discussion not only with Commission with LCDC, but we also briefed the Board of Agriculture on our plans to initiate a scoping effort to identify aspects of the program which merit further conversation. So folks who weren't following LCDC, may have been following the Board of Ag, would have been alerted to the initiative at that point in time. Throughout the fall of 2023, staff engaged in a scoping effort, and that was supported by a technical working group. We did also receive a volume of public comment throughout the fall of 2023. And that was all integrated and culminated in a summary scoping report that was presented to the commission in January of 2024. So now we're starting on the timeline that's actually on this slide. And at that January meeting, staff also reviewed the need for the rulemaking that we're engaged in right now. So in January, the rulemaking was really narrowly focused. It was focused on codification of common law. But at that January meeting, the commission received almost 2 hours of public comment asking us to do more in 2024. And so at that point in time, the commission asked staff to come back with a proposal to add additional items that could be accomplished in 2024. And we did that. In April, we came back with some additional items for your consideration, and the commission expanded the charge for the rulemaking in April. So between March and July, our rulemaking advisory committee met 5 times. We had 5 3-hour-long meetings. We received a large volume of public comment throughout the rulemaking advisory committee phase. Those were presented to our RAC for discussion. And based on discussions with our RAC and considering the public comment received, staff developed a proposal that's very similar to the one that is in attachment A today. There is one change that we're going to talk about in just a little bit. In August, rulemaking notice was filed with the Secretary of State. And this is actually fairly important because it represents a limitation on what can be considered by the commission at this point in time. So the commission may choose to modify language proposals within what was noticed. You may choose to exclude language that was noticed, but you cannot add new concepts or topics that were not included in that rulemaking notice. Okay. So I also wanted to spend just a quick moment reviewing the charge for this rulemaking. So up here, the slide is the summary of the charge. The bulk of the 2024 rulemaking is very technical in nature, and the desired outcome is, as it's expressed in this charge, really is to improve consistency of implementation by counties and add that little bit of additional clarity that is going to make it easier for counties to implement our rules. So county planning staff are the folks that interpret and implement our rules on a day-to-day basis. This rulemaking does not address fundamental policy issues that underlie the Farm and Forest Conservation Program. But it is important to note that anything that we do with the Goal 3.4 program has to be aligned with the policy intent of Goals 3 and Goal 4. And that is essentially the conservation of the limited land base that is needed to support the farm and timber economies. So I might suggest that the commission keep that sort of policy objective in the back of your mind as we're discussing the proposal today. So before I move into the actual proposal, Chair Halova, does the commission have any questions sort of on that background information?
Commissioners? No comments from commissioners.
So moving into the proposal, the rulemaking is really grouped into 3 different parts. There is the codification of common law, and those are in the topics in the blue box on the left. And we'll be reviewing those in detail in a moment. And there's a lot of discussion those again in attachment E, that legal memorandum. The second part are those items that were added by the commission in April. Those are items in the green box. And then the third part of the rulemaking is a conforming rulemaking. So in September, we also talked about items that were in the charge that were discussed by the Rulemaking Advisory Committee, but for which staff did not propose any rule amendments. So we talked about that in September. We're not going to talk about that today. Today, we're just going to focus on what's actually in the proposal that you'll be voting on. All right, so the first topic area is codification of common law. And again, common law is the body of law that is derived from court decisions. And under the American common law system, prior court decisions are really critical elements of subsequent court interpretation. So, for example, about 4 years ago, there was an important land use decision in Yamhill County. It's called Stop the Dump. It's one of the cases that we're proposing to codify. Since that decision was issued by the Supreme Court, the holdings in that case have been cited several times in different new appeals. And what has happened is that the Land Use Board of Appeals has sent those appeals back to the county. They've remanded them back to the county to run those hearings processes all over again with instructions to consider the stop the dump case and provide evidence and findings as they were described in that case. So that's an example of how that holding has been considered in subsequent decisions. And as we've discussed before, there's a large body of case law related to the Farm and Forest Conservation Program. And experienced planners in well-resourced jurisdictions, land use lawyers, they have the ability to stay up on case law. However, there is a wide variety of resources in counties across the state and abilities to stay up on case law. And that can result in land use decisions that don't conform to common law standards. And that results in unnecessary legal challenges when those standards aren't applied correctly. And that's a waste of time and money, not only for a county, but also for an applicant. So a good chunk of the language in the proposed rules related to the case law codification are quoted directly from the cases that were reviewed. The staff report summarizes where that language came from. And again, attachment E contains a deep dive into that language proposal. So the first topic is the farm impacts test, or 215-296. So this is a criterion that is applied to all conditional use reviews in exclusive farm use zones. And it is essentially a good neighbor test. So it requires the county to find that a proposed non-farm development is not going to have a significant impact on farm and forest practices or the cost of those farm and forest practices in the surrounding area. All right. So the stop dump case was very exciting because the courts provided a lovely step-by-step description of the analysis required to come to that conclusion, right? And we propose to integrate that sort of step-by-step description of the required analysis into our rules. So, first you have to identify the farm and forest operations occurring around you. If you don't know what they are, then you can't come to a conclusion of whether or not you're going to impact them, right? And then secondly, you need to consider how and whether your proposed non-farm development is going to impact those farm and forest operations. And to make that a little bit easier, we've also included a list of some of the common types of concerns that come up in these types of reviews. And it is very important to note that if significant impacts are identified during the course of review, it's very common the county has the ability to adopt mitigating conditions of approval. That is, a county can require that the development implement things to lessen those impacts. And so it's really common to see conditions of approval requiring things like vegetative buffers around a development, or fencing, or signage, or limitations on hours of operations. Lastly, we are also adding a section of rule clarifying that significant impacts to farm and forest operations from construction activities are also appropriate to consider during review. And this comes from the Von Lubken case. And so, for example, if you had a situation where there was a shared access driveway and that access driveway went through a farm operation, that farmer might be concerned about impacts from construction vehicles, bringing in noxious weed seeds or introducing biological contaminants, right? And so in that case, that might be considered in the review. A county might require a condition of approval that those tires be sprayed before they enter that section of the driveway. That's actually a pretty common construction best management practice. I do want to clarify, because we've gotten comments on this point, that for this rulemaking, this proposed rule amendment only applies to uses subject to the farm impacts test at 215, 296 in exclusive farm use zones. And I also want to clarify that utility facilities needed for public service, water lines, sewer lines, transmission lines are sub 1 uses. They are allowed outright in farm zones, subject to standards. They are not subject to the farm impacts test. So the next topic is commercial activities in conjunction with farm use. So this is the second most commonly approved use in exclusive farm use zones. And we have received a lot of public comment on this topic. So some commenters asked us to do more to define and add limitations to what can be considered as a commercial activity in conjunction with farm use. Some commenters asked us not to do rulemaking on this topic. So a wide variety of opinion on this. The charge for this item was to codify case law. All right. On September 24th, the day before our September hearing, the Court of Appeals affirmed a LUBA decision addressing these case law standards that differs from conclusions made by the department and our rulemaking advisory committee. At this point in time, we expect that the Oregon Supreme Court may be considering this case, and that resolution of this discussion could be pushed out to 2025 or beyond. Therefore, the department is now recommending that we defer adopting rules on this particular topic to a future different rulemaking as the case law is evolving on this particular topic. So the language for codification of commercial activities in conjunction with farm use has been removed from attachment A, and it has been removed from attachment F in your packets. So Chair Holova, I'll pause there and ask if the commissioner has any questions on that particular topic.
Commissioners? Looks like Commissioner Warrior.
I'm trying to figure out how to phrase this question. So this was affirmed. Is that what I'm trying to understand the process? So, and that was filed when? Is it a file? I don't understand the language.
There's a bit of a subtlety. Gord, do you want to?
Yes, Commissioner Boyer, Chair Holova, the decision by, there was an original decision by LUBA, and then that was affirmed by the Court of Appeals in September. And that decision interpreted the statute or the rule, commercial activity regarding in conjunction with farm use in a way quite different from the way we had as a department and the rulemaking advisory committee had considered to be the relevant case law. Our understanding is that the Court of Appeals decision is likely to, maybe it's going to be petitioned to be taken up before the Supreme Court. So there's three things that could happen. Number one, the Supreme Court could deny review, in which case the Court of Appeals decision would stand, differing from what we thought the case law was. Secondly, the Supreme Court could take up the case and then affirm the Court of Appeals, which is the same result. And the third option is that the Supreme Court takes up the case and, revises or reverses what the Court of Appeals did, in which case, depending what they did, if they might agree with what we had thought the case law was or come up with something completely different. So the upshot of that is that it's a very uncertain area of case law. And the whole point of this was to codify case law. So if we don't know what the case law is, we're not ready to codify it in our rules. And therefore we need to wait until we get that direction. I would note also that there are some other bigger issues with commercial activities in conjunction with farm use that might be rolled into a more general look at that topic at a subsequent rulemaking that we didn't even get into this time, but we were going to look into in the future. So that's I think would be it will be a topic that will be coming to the commission at some point in the future to resolve a lot of issues.
So did Luba decide to take this up on their own, or did somebody bring it forward to them?
Commissioner Boyer, Chair Holova, this involved a case in controversy and involving I believe in Yamhill County, a proposed use. It was appealed. The county's decision was appealed to Luba. Luba made a decision, and then the Court of Appeals affirmed Luba's determination. So it arose out of a case a case in I believe in Yamhill County.
Thank you.
Other questions, commissioners? Vice Chair Lazo.
Thank you, Chair. Gordon, I guess my question is sort of along the same lines. Well, there's two questions here. One is the case broad enough that it didn't, aren't there other elements of the commercial activities in conjunction with farm use that the RAC could have moved forward with that are outside of the scope of the case that is pending? Or was that referred to that there was other areas of scope that you wanted to approach in that area?
Chair Holova, Commissioner Lazo, there was some discussion when you set forth your charge to us about that issue, and we were going to also look at the issue of similar to when we get talk about home occupations, where there's uses that could be either home occupation or something specifically stated in the statutes. There are similar issues with commercial activities in conjunction with farm use. Our rulemaking advisory committee didn't get to those issues, and so that's an example of another area of commercial activities in conjunction with farm use that could be folded into once we know what the case law is. And there are some others as well out there that we could look at as a package in the future. But unfortunately, perhaps, we were unable to bring forward the case law part of this because of this Court of Appeals decision, which went against what we thought the case law was saying.
That's the second part of my question in general is it seems like this process, that's a possibility in any area, right? That somebody could bring a case forward that gets decided by a court that is contrary to either the way we've interpreted it or that other courts have. Because I'm assuming that this case has previous case law, as you said, that this decides differently. So isn't that possible in any of this work?
Chair Holova, Commissioner Lazo, yes, that is possible, especially I think in the case of the stop the dump case, the Oregon Supreme Court did that one. So a lower court would probably not, the Supreme Court has, is precedent for all this Court of Appeals in Luba. That could happen in other areas. Once you write the rules, I think there's even more, that really puts it in stone, if you will, to some extent that, it's not just case law, it's actually our administrative rules that say that as well. Despite what happened with commercial activity in conjunction with farm use, we're pretty confident about our conclusions regarding the rest of the case law that we're using to come up with these rules. And that's expressed in the summary of the case law information that you have in your packet.
Thank you.
Thank you. And I might also add that, it's certainly within the commission's authority to correct court decisions that you don't agree with, that you don't find in line with the Goal 3 policies. That is something that the commission has done in the past as well.
I would just add to that you can't do that if the decision is based on a statute. If it's based on one of our administrative rules, yes, you have the ability to modify a court decision that interprets our administrative rules with new administrative rule language that comes to a different conclusion.
Continue.
All right, moving on to the next topic. So these are two standards that are actually in statute. So the incidental and subordinate standard and the necessary to support standard apply to applications for agritourism events and other types of commercial events under 215, 213 sub 11 or 215, 283 sub 4. So again, these are existing standards that currently apply to event permits. The proposed rule language clarifies those standards. So there are two parts. So the first part is the incidental and subordinate standard. And there are 4 levels of event permit application that are available. And they range sort of in intensity and scope and scale. The incidental and subordinate standard applies to all 4 of those opportunities. And the proposed language for rule describes factors that a county could consider when determining that those proposed events are incidental and subordinate to a primary farm use on that property. So again, statute currently requires that you demonstrate that the events are incidental and subordinate to the farm use. The proposed rule clarifies that the factors to be considered in coming to that conclusion are the relative nature of the events compared to the farm use, the relative intensity of the events compared to the farm use, and the relative economic value of the events compared to the farm use. The second part of the proposal is the necessary to support standard, which only applies if an applicant is applying for the most intensive level of event permit. That is a permit for up to 18 72-hour-long events. So that's essentially 4.5 months of long weekend events. And it's very clear from the legislative record that the standard was meant to be a higher bar. So the necessary to support standards is in statute currently. The courts here reviewed the dictionary definitions for support and necessary and concluded that in order to be necessary to support, those events needed to be essential to maintain the existence of a farm operation or farm operations in the surrounding area. So here we are proposing to include that clarifying language from the D. Benedetti case. The next 2 I'm going to touch on very quickly. We did not receive public comment on this item. For transportation facilities on rural lands, the rule language here clarifies what transportation uses in Division 12 when they're located in farm and forest zones require the farm impacts test. Again, the agency has had a long-standing guidance document on this particular topic. Our position has been supported by the courts, and we are it will be very helpful to actually have this codified in rule. And the last topic is private parks. So here, this language clarifies what it means to be a private park in an exclusive farm use zone. And although this item was added in April, this is codification of case law and includes a description of sort of the factors that describe what it is to be a private park. All right, so before we move into the next section, are there any questions on codification of case law? Commissioner Porter.
Thank you. So just for clarification, you didn't get any comments back on either the transportation or the private parks, is that correct?
Thank you, Commissioner Porter, Chair Halova. So we did receive comments requesting us to add some additional language to the private parks rule. And this is an area where Gordon and I did not feel that that request was quite reflective of the scope of the charge, which was to codify that case law.
Vice Chair Lazo.
Thank you, Chair. Lorraine Gordon, I have a question about the change that's proposed to the necessary to support the 283 sub 4. I guess my question, there was public comment, extensive public comment around the difficulty to meet that standard currently, and it seems like the proposed language. Can you tell me how can you clarify why for me the way the proposed language clarifies the way to meet that standard? To me, it doesn't make it more difficult to actually meet it. Does the term essential to maintain essentially the viability of the farm, does that include economically? I'm assuming it means economically, right? So I guess I'm not sure how that standard works now, how it works in the proposed piece, and then what folks who are making public comment about it would like to see it work.
Thank you, Vice Chair Lazo, Chair Halova. So again, this is currently a standard. This is a statutory standard. So if you're applying for a permit to host 18 72-hour events, you need to demonstrate that those events are necessary to support your farm operation or agricultural enterprises in the area. So that's an existing statutory standard that will be in place whether we do this rulemaking or not. The clarification that was provided by the courts on that particular standard goes a little bit farther. And so if you are a county planner providing findings under this particular standard, you need to conclude that those events are going to be essential to maintaining the existence of that farm operation, that without the additional, income or attraction of new customers to the farm as a result of those events, that the existence of that farm operation or agricultural enterprises in the area might be in jeopardy. So it is a subtle but helpful clarification.
Or essential.
Yeah.
Essentially, right. Okay.
Mm-hmm. Can continue.
All right, so we're moving into the second category of rule proposals, which are the items that were added in April. So there's 3 topics here. There are repair of a circular definition of preparation, the minimum evidentiary standard for verification of income, and the home occupations topic. So farm use is allowed in exclusive farm use zones. So it is sort of the essence of what should be happening in a farm zone. And there is a definition in statute, 215-203, that describes what farm use is. So part of that definition is the preparation of farm products produced on that land. So several years ago, the commission adopted rule to expand on that definition of farm use and clarify preparation. And one of the intents behind that was to allow farmers a little bit more flexibility to prepare products that were produced on other farms in addition to their own farm. Unfortunately, the rule definition for preparation is circular. So it essentially reads that preparation of farm products can occur on land where preparation of farm products is occurring, because they use the phrase farm use, and preparation is in the definition of farm use. And that has resulted in a loophole that has allowed sort of large scale preparation facilities to be sited on farmland where no farm operation is occurring. And that preparation facilities are needed to support the agricultural economy, but they are appropriately reviewed as a commercial activity in conjunction with farm use, right? When there's no associated farm activity with it. When it's reviewed as a farm use, there's very little review that happens at the county level. And so this proposal closes that loophole while maintaining the flexibility for farmers to prepare products that are produced on other farms. The next topic is the minimum evidentiary standard to verify income. So this comes into play in dwelling reviews for farm dwellings and farm worker housing, and also at farm stands. So the income thresholds here for farm dwellings and for farm stands already exist. They are already in statute. There's some confusion, or in rule for the case of farm dwellings. And there's some confusion on that point, I think, in a lot of the comments that we received. So what this rule proposal does is establishes the minimum standard of documentation that a county requires to verify that those income thresholds have been met. And staff are recommending that that minimum documentation be a tax return receipt prepared by the IRS. So this is an official document that is provided by the IRS. It summarizes information that is on a tax return. It is free to a filer. You log online, you push a button, and you can print it out. You can call the IRS and they will mail you a copy of it. That tax return transcript shows most of the line items from the original tax return as it was filed, which is very important, including Schedule F, documenting farm income. It does not show private information like your social security number or your employer ID number. It does not show any tax account information like, you know, your tax deposits or payments or any penalties or interest or balance due. This tool is actually used in a number of different government programs that are where verification of income is required. So for farm dwellings, this information is required once at the time of application and never again. For farm stands, there is an existing statutory requirement that the income limitation be met on an ongoing basis, right? So again, to clarify and be very clear, there is an existing limitation on the amount of income you can earn at a farm stand from the sale of retail products. And these are like non-farm items like t-shirts and stickers, pumpkin carving kits, vases, or baskets at a U-Pick flower operation. And there's an existing income limitation on fees that you can earn from promotional events. So that would be maybe like a flower arranging class at a U-Pick flower operation or a pie eating contest at a berry stand for which you charge a fee. So statute currently says that income from retail items and promotional events is limited to 25% of the gross sales of that farm stand. And the intent there is to make sure that the sale of farm products is the primary focus of the farm stand. So this is not something that we are touching in our rulemaking, and we received a lot of public comment on it. That's the current state of affairs. That limitation has been in statute since 1993 for over 20 years. So I just wanted to be very clear about that. Our rulemaking is just to establish the type of documentation a county would require as their minimum sort of standard for verifying that income.
Commissioner Bennett has a question.
You, Chair Lova, and also thank you, Hillary, for all this work. I put my hand up, but
Commissioner Bennett, you're coming in and out. We know we can hear you, but it's
how about now?
no, we can't.
Okay, I'll just lean super far forward. Thank you, Chair.
No, it's not working. Sorry. Was working before. It's coming in and out. So we definitely can hear you, but it's not coming through. I guess the question is he able to write a comment in the chat box? Is that a possibility? Maybe try again talking. No,
I'll
chat's
try
returning.
once again. Is that any better?
Yeah, it's not coming through.
Oh, okay.
Maybe turn off your video. Let's see. If that helps.
How about now?
No, it's not coming through.
Okay.
It's a bandwidth issue. How about you turn back on your camera? Because otherwise I won't know if you raise your hand. And can you send an email? And then we will I'll ask that at some point as soon as somebody hands me that email. Maybe you can turn back on your camera though. Ooh, having problems with that. There we go. We can see you.
Okay,
I think you're gonna have to send an email.
I'll send it in an email.
Okay. Sorry about that. I don't know if there's anything from our side that we can do, or is it? Okay, we're asking if there's anything we can do from our side on that, on the stream.
Okay. So somebody is going to hand me that email or, okay, thank you. Can continue.
Thank you. So the last proposal to discuss this morning, in the charge, the commission asked us to clarify whether uses that have already been established by the legislature as allowable in farm zones under certain conditions may instead alternatively be reviewed as home occupations. And if they can, what happens to the standards that were established by the legislature for that use? And so this last topic can be a little confusing. So I'll go over the cidery example again. So cidery businesses are one of the uses that are listed in Chapter 215 in statute. And at 215-451, the legislature has provided a long list of standards that describe what they believe a cidery business is and the conditions under which it can be approved, including sort of additional things that happen, the types of development that goes along with a cider business, like tastings and luncheons and tours and things like that. So the question here is, if an applicant wants to be reviewed as a home occupation cidery instead of the standards that are described in 215-451, is that allowable? What happens when none of those standards in 215-451 are applied to that cidery as a home occupation? So the approach that we are proposing here is that in these cases where a use proposed as a home occupation is also described separately in statute, that the home occupation proposal cannot be more intensive in scope and scale than would be otherwise allowed under those statutory provisions. So in the case of a home occupation cidery, that cidery couldn't be more intensive than a cidery that was permitted under 215-451. So a cidery under 215-451 cannot produce more than 100,000 gallons of cider annually. It can't, host more than 18 days of events. So a home occupation cidery also could not produce more than 100,000 gallons of cider, and they could not host more than 18 days of events annually. It could certainly be less intensive. For example, a home occupation cidery may not have to meet the orchard acreage minimum standard that's described in 215-451, or the minimum supply standards that are described there. If you wanted a more intensive cidery business than was described in 215-451, you would seek approval as a commercial activity in conjunction with farm use, subject to those standards. We are also clarifying that in order to be a home occupation in these cases, that there has to be some sort of residential use happening on the property to which that business is accessory. And so it may seem obvious that in order to be a home occupation, there needs to be a home involved, like a residential use involved. But staff does believe that this is a very important clarification. Okay.
Commissioner Porter.
This is sort of tongue in cheek because I considered this question about what is a real farmer pervaded all of the comments. And I don't think there's any definition of what a farmer is. If there is, I missed it because I'm thinking the concern is, oh, there's some rich person who hires people to live in as their employee and they satisfy the conditions, but it's somehow violating the spirit. So I wondered, is there any definition of what is a farmer?
Thank you, Commissioner Thompson, Chair Halova. So there's a definition of farm use, right, in statute and in rule that we just talked about a little bit ago. So there is certainly a definition that describes what farm use is, what a farm operation is, the types of activities that are being conducted to be considered a farm use. There's no definition for a farmer. There's some subtleties there. But home occupation doesn't necessarily have to be operated in conjunction with a farm. You know, you may find a home occupation being conducted in a non-farm dwelling, for example. So for many uses, non-farm uses that are allowable in exclusive farm use zones, there doesn't need to be that nexus with a farm activity. Continue. Thank you, Chair Halova. So the last topic for our rulemaking are conforming rulemaking. And so there's a set of rule amendments that are intended to align our rules with current statutory provisions. So pages 12 and 13 of the staff report go into these in a little bit more detail. But in short, we haven't updated our rules since 2020 to account for changes made by the legislature to statute. So right now we're in a situation where there are several areas where our rules actually do not contain language that is in statute. So a couple of new uses, a couple of expired provisions. And even though statute takes legal precedent over our rules, it could be confusing that they don't match. So all of the areas here, we are simply cutting language out of statute and pasting it into rule. And again, the replacement dwelling provisions for this rulemaking are conforming. Yes, we're cutting and pasting. We are not proposing any rulemaking or interpretation of replacement dwellings. So that concludes staff's presentation for this morning, Chair. And again, Gordon and I are available to answer any questions the commission might have or support your discussion.
Thank you, Gordon, and thank you, Hillary. I'm hoping that maybe I can get Commissioner Bennett. We're still waiting on that, so we have not forgotten you. I'll go with Commissioner Porter has a question.
Thank you. I'll try to fill in the gap until Commissioner Bennett's question comes through. So, Hillary, thank you so much for expanding on the farm stand, because I was kind of getting wrapped around the axle on that one because there was a lot of comments on that 25-75 split. But expanding on that, so we're differentiating between retail items versus maybe produce or other items that are actually grown or processed on the farm. Is that correct? So what about farm stands that it kind of help to bridge a potential like food desert area, and they have like milk and eggs that maybe that they're not producing there, but they're bringing in it's probably going to be commercial stuff, since most of the milk is pasteurized, et cetera. Does that count as retail?
Thank you, Commissioner Porter. So Chair Halova. So again, this is not an issue with our rulemaking proposal, but just to clarify what the existing standards for farm stands are. Farm products can be produced for sale at farm stands, can be produced at the farm, or they can be farm products produced in the local agricultural area. And actually, there's a definition for that that is really quite expansive. That includes the entire state of Oregon. So if you're selling, and some additional neighboring counties in other states. So if you're selling eggs that are produced by a farm down the road, or meat from, maybe even halfway across the state, that would be considered a farm product for sale at a farm stand.
So that wouldn't count against the 25-75, even though that's not part of the rulemaking, but there was a lot of confusion in the comments about that.
That's correct. So when we're talking about that income limitation, again, which is not subject of this rulemaking, that's an existing standard, that limits retail items. Again, you're talking about stickers and vases and hoodies and things like that, and fees from promotional events. So there's a limitation on that to ensure that that farm stand remains focused on selling agricultural products and doesn't turn into like a normal retail store or into an events facility.
Thank you. Oh. Here's the question from Commissioner Bennett. This is about the impacts. How will this impacts impact the onion, potato processing facilities that are somewhat cooperative in organization, i.e. a group of farmers purchase a parcel and establish an onion or potato processing facility. I read this whole question. If not allowed, if not allowed, they are relocating to Idaho.
All right, thank you, Commissioner Bennett and Chair Halova. So if there is a proposed, so first of all, I would say that these rules only apply to new applications. So if there are existing facilities out there, I want to clarify that these rules are not retroactive, right? Secondly, I would clarify if you have a situation where there is a parcel that's not devoted to farm use or a tract that's not devoted for farm use, and the proposal is to develop a preparation facility there, then the appropriate pathway is through review as a commercial activity in conjunction with farm use, which we've talked about quite a lot this year. And so there would be a requirement there to demonstrate that that facility is, needed to support farms or agricultural enterprises. And so under that scenario or situation, that seems like it might be an appropriate candidate for a CACFU. Commercial activity in conjunction with farm use. Yeah.
And one other point to make, commissioners, is that, or Commissioner Bennett and commissioners, is that if the onion packing facility were on a site that also grew onions, then it would be a permitted use as a preparation facility under this rule without having to do a commercial activity in conjunction with farm use or potatoes or whatever.
So I thought Commissioner Boyer has been the commission liaison to this RAC, and I didn't know. I was sitting here saying, do we make a motion and then you talk, or do you talk? That's what I was trying to figure out. But I know that you had some thoughts. We tried to let the commissioners who are liaisons get a chance to give some thoughts on their experiences on the RAC.
I just, thank you, Chair. Some of my thoughts on, I really appreciated the process. And I hope it's a model that we use moving forward. Doing our homework ahead of time with the TAC, I think was very helpful. And I just, and my other thought was the planners are asking for this. We're trying to help make their job easier. They're confused. They cannot clarify when somebody comes to the counter. So I just need us to remember that the planners are asking for this, and we're not changing anything. Everything that's existing right now, there's nothing that's going to change. So this is just to help moving forward. And Hillary did a great job with the RAC. And again, I hope it's a model that we use moving forward. Thanks.
Any more comments and or questions or motion? Get your choice. Would someone like to, Vice Chair Lazo?
Thank you, Chair. I guess Mike, and I don't know if this is for Director Bateman or for Gordon or Hillary. I know that this is sort of as it were, the tip of the iceberg of this work. And so when do we talk about the sort of the next steps? Because I don't think that's today.
This goes. Thank you, Commissioner. We've been talking for a while about how this work is really, I see it as more of a program than a project. It's not a one-time thing. We don't have to be panicked about getting everything done all in one fell swoop. I think it's a conversation that's long overdue in terms of terminology that's either confusing and then sort of in the future moving into what more. And so I think I have indicated this to the commission before, but I've been in conversation with many of the executive directors of the ag organizations, and I've been trying to, those are networks and relationships I had before working with water and with business, but now coming from the land use perspective, circling around again to
executives of, the irrigation districts, the nurseries, the farm bureau, the cattlemen, the dairymen, they all have these associations, and sometimes they actually all get together in one room. And so that makes it handy too, to go and brief them or talk with them. And I've invited a long-term conversation with them, because we've said, this piece, this first chunk that we were looking at 2024 is really the low-hanging fruit of things that needed to be codified, defined, or brought up to date. But what are they seeing from their side of the counter? Where are their pain points? Where are things that they find confusing? What are things that they might like to work on together with us as well? And we've gotten really good response from them generally about that. And so I would think that those conversations will continue, and hopefully we can identify something informally and that we could bring back to the commission for your consideration, see if that would interest you as a further charge or next steps. But it's definitely a conversation in process.
I guess what my point is, I think we see in the public comments that us approaching this work is making folks nervous about what might happen, even though this first piece of it doesn't, is like I said, the tip of the iceberg. It's putting in existing pieces, and so I know that we can only move at one speed, but that's what I feel is this tension out there from folks that might use external sources to impact the work that we're trying to accomplish over time.
Commissioner Thompson.
Thank you. And just in regard to the public comments, I saw some that said, stop this process, probably related to some comments I made. My concern is Director Green saying nothing about us without us, and I have a bias toward farmers rather than lawyers representing. So I would just hope that we would have people who get their hands dirty involved in this, but I have the utmost respect for the work that you've all done and gratitude to you for that. And I do hope we make it an iterative process so that it remains a living document. Thank you.
Would anybody like to make a motion?
I move the commission adopt rules amendments as recommended by the department and shown in attachment A.
May I have a second?
Second.
Vice Chair Lazo seconded. Comments, discussions on the motion. No comments or questions. No discussion on the motion. I want to look to see Commissioner Bennett. Yeah, I think my comments are, we were asked, this was brought to us. What I appreciate about this is obviously there's rules already in place. There's law already in place. These things exist, and clarifying that, making it easy, not letting people spend money and time and effort to realize, to get to the same point of, what the law says. And so for me, I feel like this item is, very straightforward, and kind of, we had discussed this earlier, maybe a couple commission meetings ago, the minimum. It's like, in some ways you're like, am I even doing anything? In the sense that it already exists, we're just helping clarify it. I know that there is more appetite that we heard from the commission to actually dive more deeply into these issues. And with that kind of vision in mind, which we were talking about, supporting, working ag and forest land and their uses. It definitely highlights, I think, based on what you said, Vice Chair, also the need for education. And I think we have that issue in every department, right governmental agency has this issue. And I've found it very good in our past rulemaking, this kind of iterative process with like, okay, something comes out, somebody says, oh, it's this, and it kind of spreads. And then you're like, no, it's not actually that, like, and how to kind of have a periodic way of kind of circling back with community, making sure people know exactly what it is and what it isn't. Because I think that's really important, that people just don't feel like, oh, they didn't listen. It's like what you might be talking about might be different than what's actually on the table to discuss. So I don't know what the formal process we can have for that is. I definitely feel like I've heard a lot of interaction with that process on this and other things with the group that was being addressed, which was the planners, right, who are sitting there and saying, what do I do at every moment? So I think they're probably very aware of this is helping them, but the question is with other folks. Yeah, so that was sort of my thoughts. Commissioner Porter.
Thank you. And sorry for passing when you went around the table first time. So I kind of wanted to hop on one of the items that Commissioner Thompson mentioned, and I too am fairly sympathetic to the farmers. I mean, I represent an area that has a lot of farms, and so I've really struggled over this rulemaking, and you know, before we got word that certain items were up on appeal, I was kind of hoping that we could bifurcate some of them because it's hard to take all of these topics, and some you may agree with, you know, because a lot of the farmers in rural areas they do struggle when someone comes in and builds a McMansion and it makes it really tough to then to afford the land. On the other hand, I've worked with farmers that are pretty dependent on their farm stands and some of their activities in the agritourism industry. And so I guess maybe we're fortunate to having to bifurcate it, and it was kind of out of our control to do that. So anyway, but you know, a lot of work on you guys' part. It's a huge rulemaking, and so kudos to you guys for the amount of work you put into it.
Vice Chair Lazo.
My comment really is more. I think it's interesting that tomorrow afternoon we'll actually have the farm report that's to the legislature, and I think we ought to remember this moment in the context of that tomorrow, right? I think we sometimes think of that report as somewhat benign when it comes to us, but it really is the impetus for the work that's actually happening right now. And so again, I think it's another place where we can start to have this conversation tomorrow afternoon to say, hey, let's look at what this report is telling us. And, you know, the big TAC report that you did before sort of echoed some of those concerns that I think aren't as conclusive in the report that we send to the legislature, but they are certainly proved out in that report to some degree. So I think that's, we ought to not forget that tomorrow afternoon is my comment.
And I just, you saying that reminded me of all the sessions. I don't know if there were two of them, definitely, maybe more, where the staff came and presented to us like agriculture, Oregon, and a 101, but quite in depth about like the importance, the top crops, the issues. And so I know Commissioner Boyer, you were really a champion of like, we all need a robust education in this before going into this rulemaking. So we don't normally have that in our issue areas. And so I just remembered it like, oh yeah, I remember that. So I thought that was good. And I couldn't remember where that fit actually in the timeline, because you talked about 2023 and 24, and then I suddenly was like, do you remember where that education piece fit?
Thank you, Chair Holova. So in December of last year, almost a year ago, we had a presentation from Jim Johnson, who was formerly with the Department of Agriculture, a co-presentation sort of outlining some of the key elements of the agricultural economy in Oregon.
Thank you. And there was two presentations, I think. Yeah.
And then I provided some background on the Farm and Forest program as well. Yep.
I really want to ask Commissioner Bennett if you want to talk, but I don't know if we're going to hear you. I'm going to make a 15-minute break after
Try
this.
really
Oh,
quickly.
yay. You're there. Okay.
I appreciate this as both a rancher and a farmer. We have farming operations in Malheur County, commercial, and we're fairly large scale. So I really appreciate the work. I really concur with Commissioner Porter that with the bifurcation, I think that that's going to be valuable because some of those topics really need to be fleshed out a little more for the eastern Oregon part of our state versus the western side. And while I'm certainly not trying to taint the discussion, there may have to be a eastern western type of a look at that. But I really, and having served as a planning director, it's just a nightmare to try to come up there. When someone comes in and they have a 5-acre parcel and want to have, and they're calling it a farm, and then they want to have wedding venues, you're there trying to just scratch your head, and the neighboring farmers and ranchers are furious. It's just, it just isn't a pleasant time. So we are really going to be assisting our local colleagues a lot by the development of this. And I think a lot of work's gone into it. Commissioner Porter, thank you for your representation of the industry. And Hillary, thank you, and Gordon et al. And a big shout out to all of those RAC members too. So with that, I think it's positive. But I was concerned early on. I had a lot of ranchers, farmers with concerns when we got to that. But at some juncture, I think a crucial consideration always that it's incidental and subordinate to some of the folks that testified to us at one of the meetings. It appeared that perhaps they had the outlook slightly in reverse, that they were their activity was more, and while I have a great deal of sympathy for them, please, I'm not trying to minimize it, but we have to remember that whatever the activity that is allowed is incidental and subordinate to. It's not the activity is the premier thing. And by the way, we're now going to sell kumquats or something. So thank you, and thank you, Chair, for allowing me to speak.
Yeah, thank you. And we heard you very well. Actually, probably the clearest. So with that, I was thinking about doing a roll call. Denise.
Commissioner Bennett,
Oh, God. I hope we can-
Aye.
There you go.
Commissioner Boyer,
Aye.
Commissioner Porter,
Aye.
Commissioner Thompson,
Aye.
Commissioner Warren,
Aye.
Vice Chair Lazo,
Aye.
and Chair Halova.
Aye. And with that, the motion passes with farm and forest modernization rulemaking. Thank you. Thank you for the staff. Thank you. Let's look at the time. So we're quite ahead of time. And the question is, do we keep going? Okay. Okay. So we're going to take a break, a 15-minute break. And let's actually make it coming back at 11:20. And we look forward to seeing all of you soon. Thank you. And thank you for all the people that showed up in person for being here.
Me too.
Me too. I tried to open it and look at it, but it started off just warm in here. I have the directions. So I was like, I won't be able to do that right. Oops, sorry.
Commissioner Bennett, could you talk, please?
Are they off? No, they're not off.
I burned my tongue in my coffee already.
Commissioner Bennett, are you back with us?
No, I don't know how to.
We're live.
Welcome back. I think we're just settling in. Okay. Welcome back.
Target industries. Target industries.
So we are starting again. Everybody in the room? We're starting again. So next up, we're going to hear from Gordon Howard on item number 5, which is the Target Industries Approach Rule Adoption. I'm going to just read, because all of the things we're doing involve, most of them are a vote. So I just want to read the description and the purpose. The commission will deliberate and consider adoption of rules governing the target industries approach in economic opportunities analysis. Implementing Goal 9, which is economic development. The staff will summarize the department's proposed amendments to OAR Chapter 660, Division 9, and provide an overview of the department's engagement process that informed the rule. So with that, we have with us Gordon Howard, and please introduce your team.
Okay. Thank you, Chair Halova. This rulemaking really came about from some issues that were raised about 3 years ago now by Lee McElvain, our economic development specialist, regarding the target industry approach to rulemaking. And so I'm going to turn it over to Lee now to discuss the proposed rules that you're considering today.
Gordon. Good morning, Chair Halova, Vice Chair Lazo, and members of the commission. I'm Lee McElvain. I serve as the department's economic development specialist. And as Gordon noted, I have led the department's rulemaking effort related to Goal 9, economic development. So agenda item 5 is focused on the target industries approach rulemaking. This is the second time that this rulemaking has come before the commission. And today the department is recommending adoption of the proposed rule amendments. Oregon Administrative Rules Chapter 660, Division 9 provide the requirements for conducting an economic opportunities analysis, or EOA. This is a process by which cities plan to supply a 20-year quantity of employment land for future economic development purposes. An EOA is a foundational analysis by which cities comply with Goal 9, economic development, and it serves as justification for an urban growth boundary expansion. Many cities use a methodology called the target industries approach within their economic opportunities analysis, and the intention of this rulemaking is to define the target industries approach. Just to review the background on this rulemaking effort. The rulemaking was approved by this commission in the department's biennial policy agenda in 2023. The commission initiated rulemaking in January of this year by approving the department's proposed rulemaking advisory committee membership. The department convened the Rulemaking Advisory Committee, or RAC, in March of this year and met 4 times over the course of the year to help inform the rules. The commission held a public hearing in September on the proposed rules, and the department kept the public comment period open through October 16th of this year. And today's decision on the proposed amendment is not a public hearing, so testimony will not be accepted on this agenda item. So this slide depicts a pretty quick and simplified overview of the more common types of economic opportunities analyses, or EOA. An EOA is a tool that cities use to determine not only the amount, but also the type of land needed for employment uses over a 20-year planning horizon. EOAs typically include forecasts of future local employment growth, and they also identify local economic development opportunities, which are then translated into land need. If the land demand identified in the EOA is greater than or different from the supply that's currently available inside of an urban growth boundary, then the EOA serves as justification for an urban growth boundary expansion. And although there are required elements of analysis in an EOA, the way that that analysis is organized is intentionally flexible so that cities and other local governments can respond to changing economic conditions and opportunities. So there are several commonly used types of or methods of analysis, and they can be best understood through two lenses or sort of two choices that a local government makes when it decides how it wants to approach its EOA. The first is depicted on the left here in the screen. So this represents the choice that a city or local government needs to make between relying on safe harbor employment growth forecast sources versus developing their own forecast. And the latter is referred to by the department informally but commonly as an aspirational economic opportunities analysis. The second lens through which one might understand an EOA is sort of on the basis of how a city decides to identify the type of land need that's going to result from that analysis. And it's typical for cities to translate job growth in some way to employment land need. So we would refer to that as deriving land need from a job growth basis. But it's also common for cities to identify particular site needs of targeted industries where they see opportunities for growth and use those site characteristics and include them in the economic opportunities analysis. So that would be deriving land need on an industry needs basis. And the target industries approach depicted here at the top of this pyramid is both aspirational and has land need that's derived from an industry needs basis. So as I mentioned, it's common for cities to use this approach in an economic opportunities analysis. And this rulemaking is really just to provide some definition around this very top section of the pyramid. The target industries approach identifies a desirable industry and then includes land need in the EOA that's based on the site characteristics that are typical of that industry. So for example, a city that was wishing to establish warehousing and distribution or logistics facility might identify a large flat parcel of land that's adjacent to freeway access or state highway access and include that need in their EOA. It's important to recognize, though, that the target industries approach does tend to be applied for more land consumptive industries. That's a more common method of use. And we also are more likely to see it in an economic opportunities analysis that a city provides where local employment growth forecasts by safe harbor sources are maybe not in alignment with the city's economic development aspirations. So the commission directed the department to engage in rulemaking on this topic because although the flexibility of Oregon Administrative Rules, Chapter 660, Division 9 is critical to communities, the target industries approach itself is basically undefined. So the department was asked by the commission to provide some clarity around this approach, especially as Gordon mentioned, following the adoption of North Plains 2022 EOA, which revealed some of the concerns that the department has from a comprehensive planning perspective when the target industries approach is used. The lack of clarity on how to appropriately apply this approach in an EOA exposes cities to unnecessary legal challenge, and we believe it's preferable to create some structure around this methodology. This provides certainty to cities and other interested parties that the analysis was or was not conducted in compliance with clear rules. And we think that this is beneficial to both local governments as well as the statewide land use planning program. So the issues that the department is endeavoring to address in this rulemaking are some of the more controversial recent applications where an EOA lacks industry specificity. So this is a question of how clear a city must be in defining what type of industry it's looking to recruit or identify through this approach. Is it enough for an economic opportunities analysis to simply identify all manufacturing, or should the EOA be more specific and identify, for example, food manufacturing or semiconductor manufacturing as a target industry? And this is really an important question because different industries require different types of sites. So defining what a target industry can be within some kind of range is important to effective employment lands planning. Another issue the department is seeking to address here is that some EOAs that use the target industries approach result in larger urban growth boundary expansions. And as I mentioned during the September commission meeting, a large UGB expansion is not necessarily problematic in and of itself, but big economic development initiatives do take time to materialize, sometimes more than a decade. And the department has been hearing that there's a shortage of industrial land, specifically large lot industrial in some regions of the state. And so we are seeking to protect sites for development by key economic development opportunities when cities use the target industries approach. And finally, the department is concerned that EOAs that use the target industries approach are not associating land demand with job growth. So cities are not required to use specific employment forecasts in their EOAs, but it's the department's position that land need asserted in an EOA should reflect the number of jobs anticipated to be accommodated on those employment sites. So this is especially important if a city is expecting a large new employer to be established in the area, because that might not be reflected in other elements of the city's comprehensive plan, importantly in its housing and transportation components. So in consideration of these questions, the department sought to recruit a RAC that represented both planning and economic development interests from around the state. And the list of committee members who participated is included in attachment C of your staff report. We invited open applications from local governments around the state, both cities and counties, as well as economic development districts. And the RAC included representation from industrial real estate interests, expert consultants, and advocates representing environmental, land use, agricultural, and property rights interests. The document about this approach to the RAC and integrated many of the committee members' suggestions and feedback into the draft rule. The RAC spent the most time talking through how a local government should define a target industry, as well as how the site protections should be structured within the rule, since those are both new considerations for local governments who might be considering using this approach. One area of disagreement between RAC members is reflected in some of the comments that are included as attachment D in your staff report. And this area of disagreement is related to the question of whether the target industries approach should be reserved for special opportunities or certain circumstances by cities. So I'll now cover the key changes that are proposed by this rule amendment, and these are described starting on page 3 of your staff report. We first sought to create a definition for the term target industry to provide some clarity around how specific a local government needs to be when it includes target industries in its economic opportunities analysis to justify site needs. And the desire here is not to be too specific, because we really don't want to be asking local governments to predict long-term economic outcomes to an unreasonable degree of precision. But we also need to provide a little bit of narrowness in this definition so that local governments can be effective in identifying the specific types of sites that they're making the case for in their economic opportunities analysis. So we're asking that EOAs that use this approach refer to something called the North American Industry Classification System, or NAICS. This is a federal data set that assigns identification codes to every economic sector in North America. And as shared in the September Commission meeting, the department is recommending that cities identify target industries at the 3-digit NAICS level. And this is more specific than, for example, just stating manufacturing as a whole, but it still does allow relatively broad sectors to be included in an EOA. The rules allow EOAs to identify more than one target industry, and they also allow clustering of similar or associated industries so that economic development professionals can pursue a cluster strategy for economic development. And then finally, target industry sites may not be designated for retail uses. It is acceptable for an EOA to identify a need for additional retail service, but this rule would not allow for target industry sites to be designated for large retail development. The proposed rule also adds a requirement to Chapter 660, Division 9, Section 15, which provides the process for an EOA. This amendment would require that EOAs demonstrate how job growth is connected to land need. It would apply to all EOAs, not just target industry approach EOAs. But the method of compliance is flexible. So the proposed language states that the EOA must demonstrate how expected employment growth is expected to be accommodated on the identified sites. It does not prescribe how exactly the EOA must do that, just that local governments should try to anticipate how many jobs will result and where they will be located. This is a really important amendment because it encourages better comprehensive planning and can help local governments anticipate housing, transportation, and other comprehensive planning needs at the site level. So moving on, this issue is one of the most significant changes proposed for Division 9. The rule, if adopted, would protect target industry sites for economic development opportunities. And it does this by requiring that local governments adopt regulations that protect sites identified for target industries, which in effect preserve them for their intended use. But it's not completely inflexible. The rule language would allow sites to be developed for employment uses that are not anticipated in the EOA if the local government finds that the unanticipated proposed use would provide equal or higher local economic and community benefit. So a city would not be locked into a site for eternity, waiting for one particular specific use to materialize if economic changes predictions don't prove to ring true. The site protections clause also allows that these sites may include supportive and subordinate development. So, for example, an office supporting a manufacturing facility would be allowable on target industry sites. Amenities for workers, such as childcare or a coffee shop, for example, would also be allowed to be developed on these sites. But most importantly, the proposed rule would not allow target industry sites to be rezoned and developed for residential and commercial use unless the local government conducts a new economic opportunities analysis that indicates that the site is no longer needed for economic development priorities in the future. We did ask that the RAC help inform when and how the target industries approach should be applied, whether this should be reserved for special circumstances or opportunities, and you'll see some comments in your packet related to this topic. Ultimately, the department has recommended that the flexibility of Division 9 be maintained in this and other EOA methodologies. So this approach is optional. It is not required of local governments. It's also still available to any local government that wishes to use it. So this proposed rule amendment will not limit its use in any way. And although the department has received some comments recommending that the approach consider, for example, environmental impact analysis, we're not recommending any additional requirements of local governments that use the rule. So there'll be no additional findings or Goal 14 requirements, for example. So it leaves us quite open. And finally, the compliance requirements within the proposed rule itself are flexible, which is in keeping with the rest of Division 9. So although local governments will need to justify site characteristics for target industries and assign jobs to those sites, the method of compliance is really up to the local government. The rule is also flexible in allowing local governments to pivot to unanticipated economic development opportunities without prescribing exactly how it is that the local government needs to consider those opportunities. And that concludes the summary of changes to this division proposed by the department. Thank you very much for your time, Chair, Vice Chair, and Commissioners. I'm available for questions.
Thank you. Thank you for the presentation and the report. Commissioner Porter was our commission liaison to this Rules Advisory Committee. So I didn't know if you had any comments that you'd like to say.
Thank you, Chair. Yeah, I do. Initially, I want to thank everyone for allowing me to cut my liaison teeth on a more narrowly defined rulemaking. I do not envy Commissioner Boyer. And so, but no, this was very interesting. It was a good, beginning step for me. And I just want to commend Lee and Gordon and the staff. I've had the opportunity to sit on a lot of rule advisory committees, and I have to tell you that these guys held themselves up with the highest professionalism. The patience that they just exude was pretty impressive, and they were very respectful to everybody and managed it very well. So anyway, so thank you. It was a good experience.
Commissioner Thompson.
Thank you. I'm pretty sure that your liaison speaks accurately about you. I support that as well. What I loved was the balance between structured rationality and flexibility. I think that's pretty much ideal public policy because it does lighten the administrative burden while remaining clear on the intended outcomes. It empowers people to do the right thing and helps them understand what that is and move toward it. Thank you.
Any other commissioners? Questions, comments? Vice Chair Lazo.
Thank you, Chair. And thanks, Lee. I echo the comments. This is an amazingly light touch on this subject, which I thought was amazing. But I do have a question about one item that got added, and I think, well, I just want to make sure I clarify this. It's the insertion of the rule that to demonstrate how expected employment growth is expected to be accommodated on identified sites. The difference between that connected piece and then the next piece that is in the target industries piece about actually protecting sites. So there's an intention for those two things to be different, right? Because the first one doesn't have sort of that escape clause about if things change in economic growth. Am I reading that right?
Thank you for the question, Vice Chair Lazo, Chair Halova. You're correct that these are two separate components, and although they will work together if under the adopted new structure of a target industries approach, economic opportunities analysis, the amendment that would require all economic opportunities analysis to assign jobs to employment sites would apply to each of them in the future. And this was, I think, identified during our process as something of a loophole in Division 9 that cities could move forward with an economic opportunities analysis that didn't necessarily identify how many jobs might result from the land demand that they were asserting in that EOA.
So sort of like literally ground truths, a number that you're talking about for employment growth. Okay.
Yes, that's correct.
But it doesn't lock you into it, right? So you just make that connection between those two things.
Yes, that's absolutely true. Thank you for the question.
Any other commissioner comment? Commissioner Thompson said exactly what I wanted to say, which was this balance between flexibility and specificity. It's just lovely. I also enjoyed even looking at the NACE codes. I was even thinking the level that you picked it at kind of feels like clusters in some way because it's more broad. And then you mentioned actually you could cluster different NACE codes. I think that's what you said, right? Okay. So I was already thinking about clusters in relation to the specificity that you don't want to get too deep in specificity that you don't allow for clusters, which seem supportive of each other. So yeah, I was excited. Feels like we can move to a motion. Would anybody like to make the motion?
Sure. Madam Chair, I move the commission adopt amendments to the Oregon Administrative Rules, Chapter 660, Division 9, as recommended by the department and shown in Attachment A.
Commissioner Thompson. So Commissioner Porter makes the motion, Commissioner Thompson seconds. And with that, I think we've already done our discussion. So with that, I think I'll ask Denise to do the roll call.
Commissioner Bennett,
Aye.
Commissioner Boyer.
Aye.
Commissioner Porter.
Aye.
Commissioner Thompson. Commissioner Warren,
Aye.
Vice Chair Lazo,
Aye.
and Chair Halova.
Aye. And with that, the motion passes. Thank you. Thank you very much. So next, we're going to break for lunch. And we plan to return at 1:30. And so the question is, I think we do return at 1:30. We don't return later than that, earlier than that, since we have time. I think people, okay, 1:30. We'll see you back for item number 6, which is Goal 5 Cultural Resources Rule Making Decision. Commissioner Porter.
Thank you. Hey, since we're starting lunch early, I wonder can the IT people start some of these updates in the interim to shorten tomorrow a little bit?
No.
Okay.
Yeah, maybe at lunch we can get have them up. And Commissioner Bennett, we'll see you back at 1:30.
Commissioner Bennett, could you say a few words just so I can be sure we can hear you?
Okay, thank everybody. And also thanks to Gordon and the last group that for their presentation. And I was really delighted that they had obviously worked with all sides because we didn't have a large contingent of folks with angst.
Thank you so much.
Thank you. We'll see you back at 1:30. Cultural.
All right, let's goodness errors on cultural resources coming up next. It's exhibit.
Thank you. Thank you. And then the only way to turn these off is to pull the battery, is that right? Yeah, she's.
Commissioner Bennett, are you with us?
Okay, we're going to start shortly. We're just waiting to see if we have a commissioner online. I don't think so, because we would see a box. Okay, so we welcome back. It is 1:30 p.m. and we are going to start with agenda item number 6, Goal 5, Cultural Resources Rulemaking Decision. And I wanted to read the description and the purpose before introducing the team. So the commission will deliberate and consider adoption of rules governing cultural resource protection under statewide planning goal number 5. The purpose of this rule is intended to support greater understanding and protection of significant cultural resources and to better preserve the state's cultural heritage. And so with that, we're bringing forward Deputy Director and Tribal Liaison Kirsten Green and Gordon Howard, Community Service Division Manager. Kirsten and Gordon, please introduce your team.
I'll start. Gordon Howard, Community Services Division Manager. And for our third rulemaking meeting today, we have someone in a slightly different seat from where she usually is, our Deputy Director, Kirsten Green, and Tribal Coordinator, and also our Natural Resources Specialist, Amanda Punton, who has done the lion's share of the work on these rules. So I'll turn it over to Kirsten at this point.
Thank you, Gordon. Chair Halova, Vice Chair Lazo, members of the commission. I am Kirsten Green, Deputy Director and Tribal Liaison. I'd be remiss if we didn't acknowledge Director Bateman and the department's support for this rulemaking and the staff that have played a strong part. Thank Commissioner Thompson for being our liaison and really a guiding light all the way throughout. It's been 4 years of work, so we're glad to be here today. Consistent with both the planning program in Oregon and our government to government statutory responsibilities, we believe this rule will stop harm and improve the fabric of Oregon's land use planning, comprehensive planning program. In this area of Goal 5 and cultural areas, there have been some significant gaps which this rule corrects. As you'll hear from Amanda, after 5 rulemaking advisory committee meetings, we had a robust rulemaking advisory committee that's in your packet in attachment C, 5 meetings, a technical work group meeting, 4 online webinar and open house events, numerous gov deliveries, and 2 meetings with the commission's local officials advisory committee. We have received a number of constructive public comments on the draft rules that were published on September 1st. And as you'll hear today from Amanda, I believe we have, in consultation with legal counsel, corrected and responded to all those that we can. Consistent with the guiding principles for the rulemaking and our charge, we stayed within statutory development timelines. So the 120 and 150-day development timelines established by state law and other norms and conventions of the land use planning program, both within Goal 5 and related rules. Staff are recommending these rules as a step forward to a better, more comprehensive and inclusive land use planning system. Thank you in advance for your time and your consideration today. Amanda.
Thank you and good afternoon, Chair Halova and Commissioners. So Amanda Punton, Natural Resource Specialist with the LCD. And it's delayed.
And while we're setting up the presentation, maybe Commissioner Bennett, you could say hi, and we just want to check your audio, that's all.
Afternoon.
Good afternoon. That worked. Thank you.
Right, so ready to go?
Yes, please.
So I just I'm going to do some review of information that I've brought in past commission hearings just to get us all oriented to what we're doing here. So we are adopting or proposing to adopt a new rule for cultural areas, Goal 5 cultural areas, but this rule will refer to what we call the standard process in Goal 5, which exists in other rules within Division 23, Rule 30, Rule 40, and Rule 50. And then there's some minor amendments to OAR 660 23-250, which is the applicability rule for the entire Division 23. So at the top, we've got cultural areas, and the rule defines cultural areas as archaeological sites and landscape features of cultural interest. And I'll make a point here that cultural areas has the same meaning as cultural resource site. Cultural resources can be like an object that you hold in your hand or a play that you go to. You know, there's resources is a broader category. We are working in the land use world, and so a cultural resource site is what these rules will address. So the overall organization of the rule is, after we have definitions, we have a section that talks about how this rule relates to other rules in Division 23. And then, because we have the two categories essentially of cultural areas, we have a rule that speaks to the inventory for archaeological sites and protection measures for archaeological sites. And then we basically have a parallel set of rules that talk about an inventory for landscape areas and protection of landscape areas. So I think I just will take some time here to explain that the kind of base level protections for archaeological sites really rely on existing state laws and permit requirements that pertain to archaeological sites in Oregon. And what are, so the inventory is basically all archaeological sites. And the protection strategy it provides more opportunity or requires conversation around the potential to impact archaeological sites, but then any requirements would then fall out from the existing state laws and permit requirements if an archaeological site was going to be disturbed. For landscape areas, we don't have that kind of existing structure in state law or permit requirements for landscape areas. So this rule provides or talks about a way relying on the standard process that I mentioned just a little earlier ago for identifying significant sites within the larger area of important landscape, culturally important landscape features, and then protection for that local protection for landscape features, significant landscape features occurs through application of the standard process again, which is assessment of just the land use consequences of protecting and then resulting in local measures that would protect a landscape feature. 7, here, landscapes of interest, that's again back onto the larger category, and it has some similarities to the protection measures for archaeological sites in that it provides opportunity for conversation. Anything that results out of Section 7 really has to do with making recommendations to a landowner or to an applicant. Doesn't result in requirements, because we're talking at a time when there are not, we haven't even figured out if a landscape feature is a significant landscape feature or not. And then Section 8 talks about local, some optional options for local governments to add additional protection, and also local governments to work with tribes to come up with a more refined way of having the conversation around archaeology, as opposed to the kind of blanket coverage that we have in the baseline requirements in the rule. And then lastly, this how the different parts of the rules work together and what has to be done now, what doesn't have to be, or when it has to be done, or what doesn't have to be done, what's optional. Did you have a note? So, just looking at the parts of the rule that apply directly to local governments, and the reason why the rule has direct applicability is because that avoids having to require local governments to amend their comprehensive plans and codes. So we have a set of directives that apply directly. And so for archaeological sites, information must be included on all permit applications that will result in ground disturbance. And that information is just about the existing laws that we have and permit requirements if an archaeological site is discovered inadvertently. And then notice to tribes of applications for development that involve ground disturbance and are reviewed through a public process. For landscape areas, there's also a notice requirement to tribes for land use applications on rural lands that are reviewed for a public process. And that's the Section 7 part I was talking about, where another opportunity for conversation about important landscape features that have not been identified on a local comprehensive plan as a Goal 5 significant resource site. So to both categories, archaeological sites and landscape areas, notice to tribes required of intention to amend an urban growth boundary. And when responses to any of these notices are received by a local government, that information is shared with the applicant and included in the record of decision. And recommendations are included in the decision. What comes out of the recommendations to the applicant is documented within the local decision. And then this last little box here is added since the last time you saw the slide, and that has to do with some changes we made to Section 8 regarding local government's ability to develop additional protections for archaeological sites. And if a local government takes that on, and here we're maybe thinking of sites that aren't necessarily just tribal sites, tribes still want to have a notice that they're embarking on that effort. And then, so other provisions in the rule. So emphasizing existing requirements that are already in Division 23 about how UGB amendments are a time to consider Goal 5 resources and figure out which ones, if they're known to exist in an expansion area, what might be significant, and then continue the Goal 5 process if a significant site is determined. And that would be pertain to landscape areas. And I've already mentioned that the standard Goal 5 process applies to landscape features. So then the optional part of the rule, as I mentioned in Section 8, which talks about the option of a local government forming a government-to-government agreement with one or more tribes. And then also what's been added since the last time we spoke is this provisions for additional local protections of archaeological sites. All right, so I'm going to go through all the edits that we've made to this rule since it was posted on the Secretary of State's site. And I'm going to follow the order that these were discussed in the staff report, which means we're going to jump up and down through the rule a bit as we go, but I will give you page numbers. So hopefully we'll all be able to keep track. So we'll start with issues discussed at the last LCDC hearing and what we did with those after advice that we received from the commission. And then we'll move on to issues that were raised through public comments after the hearing. And then we'll go through some edits that staff and council just realized were needed to the rule, some which I just figured out today. All right, so you guys all ready? Yeah. All right, let's go. So for the issues discussed at the September hearing, we made edits in response to 2 of four issues. And one is, I'm going to actually start with the second bullet here, which is the relationship that this rule has to the Eastern Oregon solar siting rule, which has yet to be adopted. So the directive we got at the last commission hearing is that it wasn't right to make a reference to a rule that didn't exist yet. So we have struck that reference from this rule. And then the optional local protection for archaeology, that's going to take a little bit more time to explain. So I have a couple slides on that. And so I should say that the 2F, which was kind of removed, but there's another 2F there, which we'll get to later, but that's on page 3 of the rule. And so section 8 of the rule, and when I'm talking about the rule, it's what you have in your packet, which is the track change version of it. And so on page 8 of that, we have our section 8, which before just spoke to the option of forming government to government relationships and coming up with a different approach for noticing tribes and dealing with responses that tribes might have to notices. So what we now have is that all exists in 8A, and these new sections talk about what a local government can do, which isn't specific to tribes. So 8B says that a local government can require pre-construction surveys in areas where they've identified a high likelihood of archaeological sites existing. And then 8C says that local government can go a step farther and say that in these areas where they know archaeological sites might be, and if this pre-survey shows there is an archaeological site, the local government can require avoidance or other, limits on development, which would be beyond what the permit requirement might be for but from SHPO, because SHPO can allow some disturbance as long as certain processes happen and documentation of the site is made. So 8D, when we were talking about this provision in the rule with the tribes, they said two things. One, we came out at this first thinking it was going to be specific to archaeological sites that were not tribal in origin, and the tribe said no, don't make a distinction. So 8B, C, and D does not make a distinction between whether this approach that a local government might take is specific to tribal sites or non-tribal sites. And the tribes also asked that if this was initiated, the example we've talked about before is like a Chinatown. And so if there was if a city wanted to identify original Chinatown and have requirements there, when they were setting up that program, tribes would like to be notified about that. And okay, that's it for that. So, one second. Yeah. So what happened when we did these amendments is we also realized that that there just had to be some other reorganization, and you'll see that in some of the internal references in Section 8. And essentially what's going on here is that the government to government agreements can replace the prescribed notice requirements and how those notices are treated. But government to government agreements can't result in putting limitations on development. In order to get to that level of protection through a local program, you would need to go through the standard process and have an ESEE, which I will say out loud for folks who forget what an ESEE is, which is the analysis of the economic, social, environmental, and energy consequences of allowing, limiting, or prohibiting uses that conflict with a significant resource site. So in order to put local protections on archaeological sites beyond what is already required by the state, then they would go through the standard process, including the ESEE. And is that So that's my last slide for these issues that we discussed at the last hearing. So I want to pause to see if there's any questions. Commissioners, do you have any questions? No, you can proceed. Okay, thank you. All right, so of the issues that were raised since the last LCDC hearing during the public comment period, there were, I think, 20 comment letters. Of that, we identified 7 significant issues, or some of them overlapped, I guess. So 7 issues that we talked about in the staff report. And of those 7 issues, 5 of them resulted in amendments to the rule, and actually kind of 6, which I'll get to later, but as I go. So the ones here, if you are looking at the staff report, the issue of the legislative versus quasi-judicial review of applications, that's issue 1. The relationship between this rule and the Goal 5 significant aggregate rule is issue 3. And how local governments deal with responses to notice, that's issue 4. And then the issue around the owner consent rule is issue 5. And the deference to federal protection is issue 7. So 2 of these are simple fixes. So the first one, legislative versus quasi-judicial review, in section 4C, which is on page 4 of the rule. We just struck the distinction. So it just doesn't mention, it doesn't say that the applications need to be processed legislatively. They can be processed the way that the city or county decides they need to be processed, given guidelines that already exists for what is a quasi-judicial review versus a legislative review. And the deference to protection required under Section 106 of the National Historic Preservation Act is just written more clearly, and it states now that that process must have been completed before a local government defers to that federal protection. So here's the recognition of quarry sites, and we see for 2F again. So this is now the new 2F, which is on page 3. And it says that that protections for landscape features under this rule shall not have the effect of limiting mining within the boundaries of a significant aggregate site in which mining is authorized by a local government. So that is a subset of all the mining that occurs out there, but it's mining that has gone through a process, and basically there's a commitment made that the land that the material in the land can be mined according to the using the standards that were approved by the local government in Dogami. So the time frame for tribes responding to notices. So this is edits made to 5E, which is on page 6 of the rule. And we just weren't very clear before as to timing and what was going on here. So now the rule tries to be more clear. So we know that the notices go out. And then when a response comes back, all responses will be shared with the applicant. Responses that come in time for to be at the first evidentiary hearing will be included in the record of the first evidentiary hearing. And then it also, the section clarifies that information on archaeological sites is managed to preserve confidentiality, and it refers to 3D, and I won't go into that right now, but it is the best practices for how to take information about archaeological sites and use it for to inform your decision with trying to preserve as much confidentiality as you can. And so owner consent rule. So we had a couple commenters concerned that this rule would bump up against that. And originally we thought it wouldn't because in section 2, we say that any site that is listed on the National Register of Historic Places is handled under our Goal 5 historic rule. And the Goal 5 historic rule basically makes those sites automatically significant and then has baseline protections that apply to those sites. But the owner consent rule doesn't just speak to sites that are listed on the National Register. It also speaks to sites that are eligible for listing. And there's a couple reasons how that can happen, be eligible for listing and not listed. One is maybe it just hasn't gone through the process at the federal level. The other is that it has, but through the federal process, there's been owners have withheld consent for the designation. And so it doesn't get listed, but it's still recognized as being an important site. And here I want to make a point. Did I say we were on page 4 here? Sorry if I forgot to mention that. Page 4 of the rule. I want to make a point about the word designation here, because designation comes after a site has been evaluated for its qualities. So I will talk on the next page about an edit that says owner consent is not needed to evaluate a site for its qualities, but still we know that that for designation of a site, even in a local comprehensive plan, we would still have to be consistent with this law. And this structure, this distinction between the assessment of qualities and identifying something as significant being a step just prior to designation is a structure that's used in the Goal 5 historic rule. And yeah, I'm going to pause. I'll go back and pause there because now we're going on to other edits. Are there any questions?
Commissioners, any questions? Commissioner Porter?
My mind. So just so that I'm clear, this is a note that I had made when I was reading through this. So in 4C, the language is added there, and tell me if it's not still consistent, or if it's not still the same as what I've got here in these materials. It says a local government shall notify property owners of the application, but may not require property owner consent to such a process, such an application. So is that permissive? That they may not have to, or that they shall not?
This is a shall not, and that actually, let's see, because I was going to cover that, but thanks for bringing it up here because it is integrated into that. It's when we were talking about this issue of what role does the property owner have in this, let's start with an inquiry about what the significance of a landscape feature is. We felt the property owner should be aware, right, of what's going on, so they get information about it. But a property owner, this rule doesn't allow the property owner to obstruct the beginning of that process. So that's why it's a shall not require property owner consent for an application.
That's kind of how I had interpreted it, but wasn't quite sure. So thank you for that clarification.
All right, so
Commissioner
Thompson.
Thank you. Is that a request to change the language? Is it unclear so that we should be changing it before we promulgate it? I don't know. I want to avoid confusion in the field, and I'm not clear from that interchange what should happen.
Thank you,
Commissioner Porter.
I was left confused by it, and so if it makes it clearer, I would think it might make sense to go ahead and change it.
Steve's agreeing. Chair Halova and Commissioner Porter, Commissioner Thompson, thank you. I agree. We agree, and DOJ agrees. That would be a positive change. So thank you.
And so maybe recap that.
Okay.
What you're
So
agreeing.
if I'm following right, that what is being Chair Halova and Commissioner Porter. What is being recommended is that in 4C, the very last line, and this
Can you
is
tell us
on
what page that's
page
on?
4. In the edited part, it shows up in blue, that it will now say a local government shall notify property owners of the application and shall not require property owner consent to process such an application.
Thank you. Sounds clear. Give me a second.
So the next set of edits here are ones that weren't discussed fully or at all in the staff report. And the first one, we kind of talked about this before at the last hearing, and in the rule, the rule had some contortions. Essentially, we had a definition for sites of archaeological significance, which we pulled from statute, and we're like, oh, cool, there's a statutory definition for sites of significant sites. But as we learned or understood more about how the SHPO laws apply and the permit requirements apply and what we were thinking of with this rule, we realized there really was no distinction between a state defined site of archaeological significance and any archaeological site. So all archaeological sites are protected under state law. So we removed the statute definition from this rule and added in 3A that all archaeological sites are significant Goal 5 resources, and that is on page 3. So the next issue, and this is what we were just talking about the landscape features that could get added to an inventory because somebody applies for that to happen and pays the application fee to have that work done. And so owner consent cannot be required. And then just making a point here that the private property interests would be considered in the ESEE analysis because of the social and economic considerations within the ESEE analysis. And that is on page 4, or 4C is on page 4. So the internal references to section 6, and that's on page 7. Although I'm thinking it should be on page 8, unless I got something wrong before.
Commissioner Bennett.
Thank you, Chair Halova. I think this would be the appropriate place to ask the question, but there was concern raised that potentially significant cultural landscape feature wasn't defined clear enough or that it was abroad. And maybe it's been changed and I might be behind onto it, but I was trying to think about it in the concept of where I live, which is vast areas. And so I was hoping maybe I could understand from you a little, what are we talking about on the potentially significant cultural landscape features?
You want to start? Go ahead. Okay. So page 2 is for potentially significant, the definition.
Yeah.
So potentially significant landscape features. I think there's going to be 2 parts to your question, Commissioner Bennett, or answer to your question. So the definition of potentially significant features, that is the larger universe of resource sites of which a subset are significant. We did at the last hearing talk about concerns that we'd heard that leaving including non-tribal landscape features, culturally significant landscape features as subject to this rule seemed too broad. You know, people came and spoke to that, and the commissioners also spoke to it. And the directive we were given was to maintain the rule coverage for landscape features that are of important to non-tribal cultural groups. So Deputy Director Green is asking about or asking me to clarify about narrowing from the larger universe of a resource site to the ones that are significant. And for landscape features, that goes through the rule OAR 660-23030, which is the rule that speaks to inventorying Goal 5 resources. And the process involves kind of looking at the site and compared to other sites in the area or the region and trying to explain why that feature is either unique or somehow special compared to other similar sites. And so this rule points to 660-23030, but it also gives a little bit more direction of like what to consider in that analysis.
So the sideboards are somewhat flexible, I guess. Is that what you're saying?
Yes.
Okay.
Deputy Director Green.
Thank you, Chair. And also to Commissioner Bennett, I wonder if it'd be helpful to just recap the instances in which this might come into play. So one is an expansion of an urban growth boundary, which was actually already enabled in our rules, just not as clearly. So the notice requirement could happen at time of a UGB expansion that could invite a comment from a tribal member or other about a potentially significant cultural landscape feature. And then the others are if a local government were to proactively develop a program to inventory and protect potentially significant cultural landscape features. And the third would be if a third party, a non-government, non-local government entity, such as a tribe or other community member would come and request consideration of protection. So there's three cases. It's not ubiquitous, but I wanted to just point out when those three opportunities are that could bring this portion of the rule into play.
So Chair Halova, I could ask a little more elaboration here. Thank you, Deputy Director. I guess I was thinking Baker County has mineral extraction zones, probably the only one in the state, I think. And so would this impact activities in those zones? Because a lot of times the mining and the landscape are in the eye of the beholder. I guess I'll put it like that.
So the comments that we received since the last commission hearing was specific to aggregate sites. And I believe you're talking about mineral sites, which would be gold, silver, cadmium mining. So this rule doesn't speak to that. And I don't know if the sites you're talking about have ever been identified and protected as a Goal 5 resource. And I'm trying to think of whether that matters or not, but I mean, the simple, I guess, response is that this rule doesn't speak to that. So yes, it's conceivable that an entity could come in requesting consideration of a landscape feature, or a local government could decide to, be looking at the significant landscape features across their jurisdiction. And you would get to you first assess whether the site is significant, and then you go to the ESE process. And the ESE process considers the impact that any limitations on development designed to protect the landscape feature. You'd consider how those protections would affect the economics and social issues, in the county. And so that is where if we can't predict, but if there's already investments in a mine, then we can imagine that the ESEE analysis, it might be difficult to get to the other end of that with limiting activities that are already allowed in the county.
Thank you.
Thank you. So we're on to the bullet that mentions internal references to section 6, and much of these are on pages 8 and 9 under section 8. And this gets back to when I was talking about the new pieces that we added to section 8 and really understanding what were the pieces that could be altered through a government to government agreement and which needed to have a process that involved public involvement. And when we thought about those two pieces, we realized that references to the way we reference section 6 and section 7 in section 8 were a little confused. And so really what we've done now is we've said that if we're talking about government to government agreements, standing in for the notice requirements, those notice requirements exist in section 5 and section 7. But they don't in section 6. And so that's why there's some exclusions of section 6. Section 6 has been crossed out in some of these places. And then there's some other edits around making that whole structure work. And then we also, something I wanted to mention is housekeeping edits to OAR 66C 230250, right? So that's the other rule that's attached to this rulemaking. And when Mr. Shipsey looked at the rule and caught some older references and made some fixes there that were not in the version that was put out for public comment. And then we have the corrections, the late breaking news.
And is it safe to say that these corrections you're talking about are not substantive, that they're grammatical?
On the page on exhibit E or 1, we're calling it 1. Okay. This says exhibit E, but it's exhibit 1. Couple 3R. So let's go, if you all have this in front of you, I'll go down the list. So the first one, adding some language to 2B, and 2B is talking about how this rule relates to the standard process. So the rules that describe the standard process. And when we made those changes in section 8 about what a local government could opt to do to add additional protections for archaeological sites, we realized that required a public involvement. And so that it doesn't excuse a local government from going through the EC process. And so that's why these words, except as provided in 8C, were added to section 2B. Is that clear as mud? Yeah, but I wanted to pause on that one. Does that make sense? Sort of. Should I explain some more or go back and look at section 8?
Some more simple way of explaining.
Essentially, because the provision we added in 8 is section 8 that allows local governments to develop, to add local protections to archaeological sites on top of what the state already would require through a archaeological permit. Because that section now allows local governments to do that and says that if they're going to do that, they need to follow an ESEE process to determine what appropriate protections would be. We wanted to make this section 2E consistent with 8C.
I think if I could explain, another way of putting it would be the other section, well, this section excused public involvement or, the normal Goal 5 process for everything. And then we realized Section 8, which is an option for local governments, requires a public involvement process. So that's why this exception was put in this one to say, if you're going to use the optional method, you do have to do the public involvement process.
And let's see, I'm going to skip to the other important one, which is the bottom one, right? Oh, yeah, let's see, 1, 2, 3, 4 down, the 8A, that goes back to what I was saying about the proper references to section 6 and 7 when we're talking about the optional the options that local governments have. And this one, so this is A, so this is talking about the government to government agreements. And because in section 7, there is a notice requirement, then this 8A should allow the government to government agreement to change the notice requirement in section 7 to work better for the tribes and the local government if they choose to do that. And then the last one we've already spoken of, we just didn't catch it in this spot, and that is making clear that when an application is made to a local government to add a landscape feature to their local inventory, that they process that as they see appropriate, whether legislatively or quasi-judicially. All right, we all good? All right, so I'm going to go on to just talk a little bit about implementation and guidance, which is going to follow upon if you decide to adopt this rule today. We will follow with model language. So this would be guidance for local government. So model language for amending notice procedures and model language for informing for information provided to applicants. And so we'll shoot to get that done by the spring. And then the best practices for communicating with tribes and best practices for avoiding impacts of cultural areas. We will have that ready before the rule goes into effect, which is proposed to be January 2026. And then this last bullet here, this is a task that the Legislative Commission on Indian Services has taken on, which will be providing a list of to each city and county of which tribes have an ancestral connection to the lands that they administer. So with that, I am done and ready to move on to,
I had a question. Yeah. Okay. Tribes with ancestral connection, is that intended to be helpful to which notices they send to who? Is that the idea? So you don't send it to everybody, you only send it to the ones that.
Yes, Chair Holova, the idea is, so in some cases, jurisdictions might be sending to 2 tribes instead of 9 tribes, let's say.
Thank you. Commissioner Warren.
Commissioner Bennett has a question too.
Oh, Commissioner Bennett.
Thank you, Chair. Not to really belabor the landscape features question, but ODOT has experienced significant issues in Central and Eastern Oregon with the sage grouse and with other protections. And I'm trying to get in my mind, is ODOT comfortable that they will still be able to maintain the roadways and to operate? I know in 2 large areas, they no longer have any gravel sources, nor do the counties, and they've been scrambling just because of the limitations due to the sage grouse. And I'm, in reading through their comments, that the one, they seem to be somewhat concerned about the definition of the cultural landscape features. And I guess I was hoping to be reassured that through the work of the staff between the 2 agencies, that they were at a higher comfort level because we're experiencing issues out here where they can't work on the roadways because the counties or ODOT, because of they just can't get gravel sources, or they can't change the roadway because of limitations. And is this going to limit them, or will this just be another well, not limit them, I guess?
So Chair Halova, Commissioner Bennett, we did make one change in response to ODOT's comments, and that is what I mentioned earlier in section 2F, which is to say that once a site has been established as a significant Goal 5 resource site and local permissions have been given to mine, that those can't be altered by a subsequent listing of a significant landscape feature in a local comprehensive plan. So that speaks to the aggregate source issue, which I know ODOT has. As far as working within the right of way, I can't speak to that as much, but I will say that two things: that one, being a state agency, ODOT already has a obligation for government to government consultation with tribes. And two, when not state money, but when federal money is involved in road repairs or extending roads, then we have federal protections that would kick in, or federal considerations for cultural resources that would kick in. I know it's not a great answer, but that's what I have.
If they were going to do a major alignment of, say, Highway 20, it may not occur because of some of these limitations.
So right now, the rule does not put in any limitations for landscape features. Any local protection measures for landscape features would come after a significant site has been identified, an EC process has been followed, and a code has been amended in order to implement the decision that's supported by the EC analysis. So we don't have anything right now concrete that we can speak to on how a road realignment might be affected. With regard to archaeological sites, all the protections for archaeological sites already are something that ODOT takes into consideration, and know, they've got a whole section of people that work on that.
If I could add something, Commissioner Bennett, I would note that if someone did come forward with an application for a significant landscape feature in an area where there was an existing state highway, that would obviously be a conflicting use that would be of a significant, very significant when the county did the analysis of the environmental, social, energy, and economic consequences of a protection measure for significance. And ODOT would certainly be involved, I would think, in that process to know if they were planning any future realignments or additions or expansions or anything like that, and would certainly have the ability to participate in the process. There would be no surprises there anywhere.
Thank you.
Deputy Director Green.
Thank you, Chair Halova and Commissioner Bennett. Just one more just affirmation I would make to the point of ODOT's concerns, and specifically your comment about the realignment of Highway 20. I would think that it's been mentioned, but federal dollars would be involved, and through the NEPA process, that tribes have to be consulted in that process as well already. So this rule doesn't get in the way of any of that. And I think what Amanda explained too is, the archaeological protections sort of are notwithstanding this rule. This is clarify, and then the cultural areas, someone would have had to go through and establish a process, as Gordon described, that would illuminate any potential conflict between future roadway and a cultural resource site.
Thank you. And I should make sure and say that I really don't foresee an alignment of Highway 20 in the near future.
Yeah.
Or probably not even in my lifetime. So thank you.
Thank you.
It's great questions, though. Great questions. Commissioner Warren.
Can you talk to me a little bit about the notification process? So there were some comments received, or maybe one comment received, about having to notify tribes 2 times. So upon reception of an application and then upon it being deemed complete. Can you talk about why we'd want to do it 2 times, please?
So when the idea was first discussed with tribes and with the RAC, the first time was to give more time essentially for a tribe to respond before any action was taken. So an application comes into a local government, they have 30 days to review that application and deem that it's complete. So the thought was, well, let's use that 30 days to give the tribe some more time. I'll say that we realize since that just because local government can take 30 days, they don't always take 30 days. So it's not really there. And the tribes didn't like, it wasn't sufficient to get an application that might be incomplete. So the tribal representatives said they wanted both. And I think this change was made prior to posting for public comment, that what the rule says now is that second notice is really just you add the tribe to the whole group of people that get notified of the complete application. So that shouldn't be onerous for the local government. And then the tribe, and it just says, tell the tribes where they can get that information. So that's why we have the 2 notices and why the rule is written now the way it is, to try to reduce the impact on local governments of that second bit of information they send to the tribes.
Deputy Director Green.
Thank you, Chair Halova and Commissioner Warren. The other reason is to help inform the development. Actually, I think we missed, forgive me if I missed it, but the applicant then having any information the tribe might provide could help avoid impact to a resource. So it's meant to be to support dialogue between the applicant and if there were a sensitive resource of concern the tribe wished to point out and wish to go on record about, then that conversation could happen between the applicant and the tribe directly, and then be reflected in the complete application, the findings, and then the procedure. So it's meant to elicit conversation, if you will. Thank you.
Commissioner Porter.
Thank you, Chair Halova. Mine is related to Commissioner Warren's as well, and it's in section 5BA. And we've got a fair amount of language that is stricken in the copy that I have. And thank you for, I was going to ask, what the completeness determination period is, but so 30 days isn't mandatory. They can move faster. So can you kind of flesh out why that the language that is stricken was stricken? I would at first blush, I would have thought that language would have promoted discussion with the applicant and the tribes, and maybe keep projects maybe a little bit more on track for schedule. Do you know why that language was stricken?
So I'm just looking at it because I think part of it was reorganized, and that's what I'm looking at here.
Did you say the section again?
Yes, it's 5BA.
What page is that on?
It's on page
Yes,
5 of 12.
Oh, is that where it gets out of there? Okay. So if you turn to page 6 and look at, we're still in 5, but now we're 5 little e. That picks up some of the language that was struck from 5 little b capital A.
But it may not just be as timely. Is that I guess that's my.
And So before, it wasn't really clear that when an application was received, what the local government's obligation was. So we've tried to be clear now that the local government's obligation is to always give information what's as appropriate to the applicant, and then include information in the record if the response is received in a timely manner.
If I could add, Commissioner Porter, the new section E basically says whenever the local government gets anything from the tribe, they're going to inform the applicant. The old language limited that to prior to the completeness determination. So I think this language is, if it comes before it's complete, after it's complete, whenever it comes, the local government will inform the applicant of that.
Thank you. And that would mean that, as Deputy Director Green said, if the response came very early, the applicant might decide to change their application, maybe change their site design. Or maybe they'll say, oh my goodness, this is going to take a lot of time to figure out how to avoid this archaeological site. We need to put a pause on this. But if it doesn't come in within that review of the application, then the information would still be pertinent and used by the applicant and the city or county as needed.
Deputy Director Green.
Chair Harlova and Vice Chair Lazo and Commissioner Porter. The tribes get a lot of notice. So I think part of this was to free everybody from that 30 days. It is really fast, as you imagine. And also, as Amanda pointed out, the local government could act more quickly. So they could be complete within a week or two. So that's almost impossible for a tribe to respond in that time. So this just, it opens up the period a little bit more. It provides opportunity for early communication, but doesn't kind of create so tight of a window that it's missed. The opportunity is missed, I think. And I should say, the tribal representatives in all 9 tribes, we're very fortunate, never seen anything like it, participate in this rulemaking process. So we can understand it's very important to them and corrects kind of a gap we missed in the 70s and 80s in comprehensive planning in Oregon. They will have to filter tremendously. I mean, this will generate a lot of notices on tribes. And they still say, please give us the information, let us decide. So that's why it is so broad. We tried to limit ground disturbing activities. Amanda tried her hardest. Like, could it be a size? Is there any way to limit it? And folks have said it's so unknown. The resources are so unmapped. Let's just create the conversation and go from there. So it will be interesting to see how this rolls out on both sides for local governments and for the tribes. There may be tribes that, in fact, we have indication that there may be a tribe that could easily change their mind that may not want to receive the notice because they already received so many notices and they have limited staff, very limited staff to be able to process. So it will vary by tribe and by area a bit as well. Thank you.
Commissioner Porter.
So is it fair to say then that and I totally agree to, the tribes should get notice of everything that they want to get notice of just in case, right? Well, is it fair to say that the applicant then will receive any feedback within 30 days or less?
Yeah, I have to find the spot, but we settled on the word when. So it says that we'll inform the applicant when the response comes in. So it doesn't say within a certain number of days. It just says when they get the information, they give it to the applicant.
Yeah, the concern there is that hopefully the applicant gets timely feedback as well. And
Commissioner Warren.
To build off of that, the applicant's not necessarily waiting for the tribe to respond, just to be clear, right? We're giving the tribe an opportunity to provide response or notification if they choose to, but the application is still moving forward. Correct.
They said correct. That's kind of low on the mic. Vice Chair Lazo.
Thank you, Chair. My only question is around the public comment received from the Cowlitz tribe. And I thought this actually, I'm not sure about the timing. Did we address this before or did the Cowlitz tribe have an opportunity have you had a chance to discuss this with them?
Alova and Vice Chair Lazo, we did actually before the close of the comment period. So we were able to have a conversation with them. I won't represent that they were satisfied with Oregon's rubric, if you will, of how we prioritize federally recognized tribes in Oregon. And it's kind of harm on harm, right? I mean, I think in this room and for the listening public, we know that there wasn't Oregon tribes and Washington tribes before there was an Oregon. There were people using both sides of the river for thousands and thousands of years. So what I understand from talking with the Tribal Historic Preservation Officer and a member of the Cowlitz Tribal Council, when Eman and I were able to meet with them by phone, that they are concerned, very concerned about what happens on both sides of the river. Local governments can and do voluntarily give notice to Washington tribes. It's very different and unique in the Columbia River Gorge National Scenic Area where it's required, but even outside, it's possible to do voluntary. We were advised to keep it in this rulemaking to the federally recognized tribes of Oregon, though. And then in our guidance, we'll continue to encourage local governments to provide notice to whomever they wish to build a relationship with. Thank you.
Thanks. I wanted to give an opportunity to Commissioner Thompson as our commission liaison to see if you had anything you wanted to add.
Long to quote Monty Python and say now for something totally different because, well, wasn't this just an honor and a privilege to be involved in an effort to do something that hasn't been done before but needs doing, where we're blending and harmonizing different cultures and exercise in international diplomacy. And we're looking at property rights and what all of that means, and then preserving the sacred character of the land and all that that means. This is our best effort. I appreciate the small couple of words we need to change. I appreciate very much all of your thoughtful attention, your questions and comments. I hope we can go forward with that small amendment. What I also hope is that we can come back, that this is in fact an iterative process, that we're looking, how's this working? Did we do it with a light and deft touch? Did we go wrong? Help us do what the forestry people call ground truthing. And I'll be interested in ODOT's supply of gravel in Eastern Oregon. You know, that's an important thing to consider because even if what we have is already approved, that's going to run out someday. Then what? So paying attention in an ongoing way, being flexible and adaptive. I think that's what we all are committed to doing in the most honoring way possible. So.
Thank you. I didn't know if there was any discussion wanted to have before making a motion or Commissioner Boyer.
Just wanted to piggyback on Commissioner Thompson is I appreciate the flexibility of the implementation also to be able to flesh it out. So I like that flexibility and giving this a year to kind of implementation. Thank you.
And I wanted to sort of ask, it's like an ask comment. I wrote down like notice requirements, opportunities for conversation, asking for feedback from tribes, and clarity. That's sort of like what I wrote. Is that safe to say that you feel that is what this rulemaking does? And the reason I ask it like that is because that's how I understand it. But there's a lot of very specific words and references and tables and charts. And so I'm like trying to get the higher, I mean, I know what the higher level, conversation, let's say vision. But as far as this limit of rulemaking, it feels like it's really about noticing conversations, feedback, and that. Yeah.
Major Halova, thank you. I feel that way. I'm going to turn it to Amanda and also to Gordon, but that's right. This is, for me, that is primarily what it is. It's an opportunity to participate, an opportunity to receive notice. And, we're we harken back to land acknowledgement this morning. We're grateful for the use of this land and how can we do it better in collaboration for those that came before us for many, many years. So for me, that you hit it on the head. Amanda, I think further.
Chair Halova, I also agree. And I'll say that there was some conversation in writing the rule language is whether the rule should be more flow better for a layman's reading it. And we kept it kind of more concise rule language, but since we're going to follow up with some guidance, then that should help local governments, tribes, anybody who's interested understand how we think the rule will be applied. And an example of this is after the Goal 5 historic rule was adopted, Rob Halliburton, who was a manager at DLCD at the time, worked with people to put together a guidance for that rule. And it's very helpful. And hopefully we will have something that is similarly helpful for this rule.
That's in relation to the best practices for communicating with tribes, best practices for avoiding impacts to cultural areas. That
yes, and more. I mean, we could actually walk through the sections of the rule and what we think they are, what we want them to do, how they should be applied, and then within that, there's definitely opportunity. Well, yeah, so I think it's a little bit more than what is written here and what we've listed here, and it might be incorporated into some of these guidances listed here, or maybe it's a separate guidance.
Hello.
Yes, Deputy Director Green.
I just have to chuckle because Amanda is being really good to limit her bullets to 5 bullets per slide and 5. I'm trying to do 5 sentences per bullet, and so there is more there. I hope that I really love what Amanda said, which was sort of a layperson's guide to the rule, because it is complex. It is hard. It took me a long time to figure out why are we 3 and 5 and 4 and 6. You know, it's challenging to read. So just some how to read the rule guidance, I think, will be welcome for even those with 30 years practice in the field. Thank you.
Commissioner Boyer.
So once a site's been identified, this is such specialized work. Was the lack of qualified professionals discussed at the rec level? And I'd just be curious what that conversation was like.
Chair Halova, Commissioner Boyer, yes, and that is a large part why the part of the rule that applies directly doesn't require involvement of a archaeologist. So the local government might get information that there's a high likelihood of a site in an area, and then the local government would recommend to the applicant that they get a archaeological survey done. But the local government wouldn't require that unless they go through the process described in Section 8. And I have heard that just around the state, it's hard to get positions filled, archaeological positions filled around the state.
But to clarify, because that's what I understood, we're not, and I saw it, we're not requiring local governments to do any of that you just said, but we're giving them the option to do that if they want to.
So Section 8 has the option of a local government identifying areas of high likelihood of archaeological sites. And within the other parts of the rule, so Section 5, so protection of archaeological sites, that section of the rule the most it results in is recommendations to the applicant that hopefully the applicant would follow, or the applicant would be made aware that they could run into time delays if they continue because of inadvertent discovery. Because if they do run into a site, they're going to have to stop their construction. But all of that under protection of archaeological sites in Section 5 results in recommendations to an applicant, not requirements. There's only one time when the rule talks about a requirement to an applicant, and that is when the city or county receives information of a site that is on the ORA, the SHPO database of archaeological sites, and it has already been, I'm forgetting the term, but like somebody has established the boundaries of the site. So the boundaries of the site both go out, laterally, but they also go deep. So you've got this shape that is defined by what the site is. And if that has happened and somebody is proposing to do development in an area for which the boundaries have been determined and are in aura, then the local government must require the applicant get either a permit from SHPO or a letter saying that a permit is not required. Other than that, everything that goes to the applicant is advisory.
We're just trying to distinguish between what we're saying to do versus what the local government chooses to do. Okay. I don't know if there's any more comments, questions, motions, thoughts on where we're at, given these some of them small clarifications. I don't know. Commissioner Porter.
Thank you. I'm Chair. I'm trying to figure out how to word this question. So, can you say whether or not you all and the RAC feel like this is ready for prime time at this point, or do you think that you could have used more time to finalize the language, I guess?
Chair Halova, if I may. Thanks, Chair Halova, Vice Chair Lazo, and Commissioner Porter. I grabbed the mic away from Amanda because she would have always wanted more time, and who wouldn't? Rightly so. It's a complicated set of rules in a short amount of time, but we have been in development for 4 years. So the model that we mentioned earlier of some pre-work with the Technical Advisory Committee on farm forests is kindred here with a work group of tribal representatives, even trying to get our arms around what these resources are, how public can they be, et cetera. I feel we are ready. I do feel we've sort of beaten around it now for quite a while, and I feel like it is time to begin. That's our recommendation as an agency. Very happy for that additional year, to continue to work on those notices for local governments. I'm also very grateful that Director Bateman directed our Grants Advisory Committee to increase the amount that goes to every local government for sort of housekeeping measures, from $1,000 to every small city and community in Oregon to $2,000 this biennium, and from 4,000 for counties, I believe, to 5,000. So there's a little bit of housekeeping budget for cities and counties to process these. Do we want to add more load to local government's desks? No. Do we want to make things better for all Oregonians and live here better in harmony with those that came before us? Yeah. So I think even the comments received from local governments that describe the administrative burden of a double notice or notice didn't say don't do this. You might notice, the tenor wasn't stop these rules, don't do this. And League of Oregon Cities, Association of Oregon Counties have been with us throughout the entire way. And we also don't have letters from those organizations saying don't do it. So I think the absence of acrimony is actually a very positive. And the 9 tribes recommended and brought this to us. So I think that, I'm sorry for the long-winded, but I do feel like I would recommend that we begin the actual work, and then, as Commissioner Thompson invited, come back and be together in implementation. Amanda?
Chair Halova, Commissioner Porter, I'll just add one thought to that, is that the realities that we needed to work with to create this rule aren't going to change. So even with more time, we would have the same issues that we're working around. So for that reason, I think we should, that's why we're recommending adoption. And I like the idea of a look back in a couple years, and I'm appreciative of the extra year we have to help local governments get ready for its implementation.
I don't have anything to add. I agree with both of my esteemed colleagues. I guess I will add that, sorry. It is key that while local governments do have some additional responsibilities, for the most everything in here is it's not new requirements of developers that aren't there already, because there's already a designated site that was described, and it's mainly informational to get the information out there so that an applicant can potentially avoid a future difficult problem down the road when they do an inadvertent discovery, and the tribes notified them that, well, there may be a site here, so that the applicants, I think, will benefit from that too, in a way.
Yeah, I mean, for me, I know you guys been working on this for a long time. It was something that was brought to us a while ago that we kept on trying to put into the agenda, trying to put, and obviously had very good reception from the tribal communities in relation to us even doing this work, period. I think any hesitancy I'm feeling right now has nothing to do actually with the substance. It's more these little edits made kind of in the moment. So trying to grasp around, like, do they have any significance, or is this like a typo, that kind of stuff. And so that's why I'm sort of like lingering, just to be like, okay, how does the commission feel with doing it today? And I'm not saying that anything in relation to the substance, actually. Commissioner Thompson.
Madam Chair, the old adage, the perfect is the enemy of the good, occurs here. I'm comfortable, I hope my colleagues are, with making the minor edits, including that one that replaces but may with and shall. I think that would get us close enough and good enough to proceed, and I'd ask your indulgence with that. Could I make that motion?
You can make the motion.
Do I have to repeat all that? So, all right.
You do have to
yes,
read
let's
this motion.
All right. I move the commission adopt amendments to Oregon Administrative Rules, Chapter 660, Division 23, as recommended by the department in Attachment A, with the following changes, which is the edits contained in Exhibit 1 and in 4C, the last line, to replace but may with and shall, so that capital A reads, a local government shall notify property owners of the application and shall not require property owner consent to process such an application.
Nice. Do I have a second?
I second.
So Commissioner Thompson makes the motion and Commissioner Boyer seconds. Any more discussion on the item? Commissioner Porter.
Thank you. Chair, just to be clear, was it the one that I had brought up, I think was 5BA. And I didn't know if you wanted to include that in your motion. You didn't. That one change. 5BA?
Thought it was for the same thing.
Proceed.
Yeah, that's what I had to.
Because I made it.
Yeah.
My bad.
Yeah.
You're right.
It's for.
Yeah. You're right.
Yes.
You're right. I'm sorry. That was my mistake. Thank you and sorry.
Commissioner Bennett.
Happy to be correct on that.
Commissioner Bennett.
That's just one clarification, because I do think we need to move forward, but there may be some hiccups along the way or some unforeseen issues. Does the commission have the authority to give an extension of implementation date so that the challenges could be worked out if they're substantive?
And I'll add to his question. This slide 17, I guess, maybe move back to that real quick about the implementation. Were you, Commissioner Bennett, saying, so they're essentially giving a year for this kind of guidance documentation? And
if we discover within the year that because of funding, staffing, archaeologists, whatever, that it was somewhat unrealistic, that could we grant extensions, or can the department grant some extensions as long as people are making or agencies are making progress, not just extended into forever?
Yeah, and I guess to add to his question, this implementation guidances are us doing this, right? Not anybody else. And so, yeah.
That's correct.
Okay. So I guess you're saying if we need more time, it does have to finish in the fall.
And Chair Halova, if I may, if I could be clear with Commissioner Bennett, just to see Commissioner Bennett, you mean if the local governments need more time to adopt their notice requirements? So that's, I think, the key piece. And we do want to, lean in with we'll be asking our regional reps to help us in keeping track of who has adopted. That's, I think, what you mean. If local governments need more time to update their notice procedures, we don't want to leave, the reason for the extension is that we didn't want to leave anyone hanging, just saying, because honestly, the commission could have made the rules apply directly today and required immediate notice, but with many, 270 small local governments out, need time to just adopt their procedures. So our staff in consultation with other local governments said, yes, 6 to 9 months should be adequate. So Commissioner Bennett, I think you're saying if folks needed longer than that 6 to 9 months, could the commission extend that timeline?
Thank you. Yes, Deputy
Right.
Director.
And then, yeah, if we could, Council
Shipsy.
If the commission wants to have a longer implementation period, we should put that in the rule now, because otherwise we would have to have a new rulemaking to change that date. But in terms of the implementation guidance and stuff, that's internal, and that wouldn't require an extension. That's within the department.
Was there any sense from, I guess, any jurisdictions that was too short or not adequate?
Chair Halova, thank you, Vice Chair Lazo. We when we extended it a year, we did not hear any further discomfort. So I think we will need to act quickly. Amanda was hoping for a couple-month break, I think, but we'll have to work on that notice requirement right away, so local governments have that in their hands and have a good 9 months to process it, and then just be in touch with them and support.
Yeah. Commissioner Bennett. Yep. Okay. Thanks. Related, unrelated. I mean, it is related. I just thought I'd share that a Portland community member who's also a citizen of the Confederated Tribes of Warm Springs reached out to me and basically told me that they testified in the Portland City Council meeting on the, I don't even know, MPAP and streetcar expansion public agreements process, and essentially brought up the DLCD's approach to cultural resources as a positive example and model that the city of Portland should consider in how it relates to tribes. And so I felt like that was pretty significant that someone reached out to me and said that. I was like, wow, okay, we're in the process, and it's already being thought of as a potential model for other jurisdictions. So I've been very proud of the fact that it's an act. That's what I was talking about before with the land acknowledgement. Like, it wasn't even a topic when I'm going to be 7 years on the commission, not even a topic. Then we get land acknowledgement. We all are like, oh, what are we doing in relation to this land acknowledgement? Then, I would say, Deputy Director, your leadership on bringing this, forward, and really the relationships that have been formed. We talk a lot about relationships as if they can just kind of manifest in a second, but we all know that it takes years and time and trust, especially when it comes to communities of color and tribal communities. So I was very pleased to get that kind of unsolicited feedback that trust building is being recognized in that way. Yeah. And I think also these implementation guidelines kind of builds on that it's not just, okay, pass some rules and hope it works out, like that it's actually being supported by the organization. And best practices, I think that's something we've been talking about with public participation. And so the idea of best practices in other ways, in the kind of layman's terms, I think is hugely important. I think we're going to go to vote because we've already had a motion in a second. Denise?
Commissioner Bennett?
Can you hear us, Commissioner Bennett?
Aye. Yes.
Commissioner Boyer?
Aye.
Commissioner Porter?
Aye.
Commissioner Thompson?
Aye.
Commissioner Warren?
Aye.
Vice Chair Lazo?
Aye.
And Chair Halova.
Aye. And with that, the motion passes in relation to Goal 5 Cultural Resources Rulemaking decision. Thank you. Thank you. I was reminiscing that we haven't done this kind of dialogue, probably with none of you here, but I went early on in the commission. We used to have we were active in rule making, changing like on the fly. So we did not do that here today. There's just a couple words, but I was reminded that that actually has been I don't know if Commissioner Warren, you were around when we did that more, but I was reminded of that. Yeah. So it's good to get to the final product we all want. We're going to take a 15-minute break, which is going to make us back here at 3:15, like literally on time. The next item we'll be talking about is item number 7, which is Goal 10 Oregon Housing Needs Analysis, ONA rulemaking decision at 3:15 p.m. See you then.
Take your battery.
Stand up anyway.
We'll take your battery out.
Oh.
Yeah.
You just put on this.
Yeah. Right. Like the main event.
You're not into
You. We're going to welcome you back to the December Land Conservation and Development Commission meeting. We are moving on to agenda item number 7, which is the Goal 10 Oregon Housing Needs Analysis, which is considered ONA rulemaking decision. I'm going to go through the description and the purpose of this agenda item. So the commission will deliberate and consider adoption of the first part of rules implementing the Oregon Housing Needs Analysis Program. And the purpose of this agenda item is for staff to present the recommended rules for implementing the ONA program for commissioners. Staff requests that commission adopt the proposed rules during this agenda item in advance of the statutory adoption deadline of January 1st, 2025. This item does not have public comment, as that's already been included in the past rounds. And I wanted to say that this agenda item also has two motions, not just one. So keep that in mind when we're going through. And so now we're going to hear from Ethan Stuckmeyer on the adoption of the Oregon Housing Needs Analysis rules, and welcome and introduce your team as needed.
Thank you, Chair Lova. Good afternoon. My name is Ethan Stuckmeyer. I'm the manager of the Housing Division, here today to present on the Oregon Housing Needs Analysis rule adoption or proposed rule adoption. On my right are the true experts here when it comes to the Oregon Housing Needs Analysis: Mari Valencia Aguilar, Celestina Teva, and Thea Croman. And we look forward to overviewing these rules with you today. We've got 3 things on the agenda. The first is overviewing those rules. We'll go through the process of kind of setting the stage a little bit. We'll talk through the proposed rules as they've changed since the last time the commission has heard these rules in October for the public hearing, the final amendments that were made. And we'll ask the commission to take 2 actions today. The first is to deliberate and consider adoption of the final proposed 2024 Oregon Housing Needs Analysis rules. We will also take a second action, or requesting that commission take a second action to amend the Oregon Housing Needs Analysis rulemaking charge to shepherd in the work of the Rulemaking Advisory Committee in 2025. And as Chair noted, this is not a public hearing and there's no public comment taken. So a little bit of housekeeping before we jump in here. The slides are many and the conversations are, the topics are dense. So when you see a dark blue slide like this, just note that it's a topic change and it might be a good time to pause and ask questions if you have them. And then the mint green color is kind of to indicate that the commission is getting set to take some action or have some deliberation. So just a little bit of level setting there. So in terms of the Oregon Housing Needs Analysis and where it sits within state housing policy, I'm going to kind of, this is a section that the commission has heard several times at this point, but for good measure, to make sure that we're all on the same page, the Oregon Housing Needs Analysis is many things to many people and is several pieces that come together as part of a implementation of the statewide planning goal number 10. The Oregon Housing Needs Analysis is that statewide methodology for housing production targets and needed housing allocations. It is an obligation for local governments to affirmatively further fair housing. It is related to housing capacity analyses. It is related to housing production strategies. It's related to tracking and monitoring. But at the end of the day, the Oregon Housing Needs Analysis is a suite of programs that direct the implementation of statewide planning goal 10 housing. There are several agencies that are tasked with supporting this implementation of statewide planning goal 10 when it comes to the Oregon Housing Needs Analysis. Department of Administrative Services, DAS, the Oregon Housing Community Services, and DLCD form kind of that tri-agency collective that is implementing the ONA initiative. And each of these agencies play a different role. The Department of Administrative Services is the numbers, the folks who manage the numbers. They run the Oregon Housing Needs Analysis methodology and publish housing production targets and needed housing allocations. Oregon Housing Needs or Oregon Housing Community Services is the agency that tracks the progress. These are the folks who are publishing things like the Housing Production Dashboard. They're publishing things like the Housing Equity Indicators Dashboard, how cities are making progress towards those needed housing allocations and the housing production targets. And then there's DLCD. DLCD is the agency that facilitates statewide planning goal 10 and goal 14 implementation, right? And we are the agency that is reviewing things like the housing production strategies, housing capacity analyses, and administering the housing acceleration program. And those are direct responsibilities of the department. So yet another graphic that the commission has seen many times, but once more for good measure. This diagram illustrates the implementation of statewide planning goal 10 under HB 2001 and the Oregon Housing Needs Analysis. So this diagram is really useful to kind of orient commissioners and others to what we're actually talking about when we get into this next section about the actual rules themselves. And I want to note here that statewide planning goal 10 applies to all cities in the state, but particularly when it comes to the Oregon Housing Needs Analysis, there are expanded obligations for cities with a population 10,000 and greater, Portland metro counties, and jurisdictions in Tillamook County under Senate Bill 406. And so when we're talking about these rules, we're talking about implementation of statewide planning goal 10, but we really are talking about requirements, regulations for those particular jurisdictions of this particular size, and as are named on the slide here. So diving into the this graphic a little bit further, when we're talking about implementation of statewide planning goal 10, we're really kind of talking about three buckets of work. The first is this kind of early stage process of determining, the first step is determining housing need. And that's done through both a quantitative and qualitative assessment of housing need, and is done both by the state and local governments to provide information for the purposes of determining that need. The second is, once we've identified that need, we as local governments take the actions that are responsive to that identified need through these two primary elements of the statewide planning goal 10 process, the housing production strategy and the housing capacity analyses. And finally, the kind of newest portion of the statewide planning goal implementation is tracking and monitoring progress. As we're identifying those needs, as we're taking that look at the future needs of our communities and we're taking those actions, how are we actually doing? Are we making progress? Are we addressing those needs? And we'll talk a little bit more in detail about what it means to actually track those and what it means to actually take those actions that are meaningful and responsive to need. So we've got our first dark blue slide here. Just a chair, if commissioners have any questions, I'm happy to answer those about just where ONA lives within the statewide housing planning framework.
Commissioners, any questions? Commissioner Thompson.
Thank you. I'm struggling with how to do fair housing. I would say ground truthing in a rural area, because I had somebody reach out to me. I tried to work with that person. I can't say I thought there was a successful outcome. I didn't see results. And so I'm uncertain about what that means. If you could clarify a little for me, what it actually means in operation.
Sure. Chair Lova and Commissioner Thompson, I'm wondering if we could actually have got a good chunk of this presentation dedicated to that exact question. So I'm happy to just have that discussion if that's still unclear after that.
Any other commissioners?
Thanks. Okay, thank you, Chair. So moving into the actual rulemaking process here. So way back when in mid 2023, when the commission took action to initiate this rulemaking process, the commission provided this rulemaking charge to the Rulemaking Advisory Committee and technical advisory committees and to staff. I'm not going to read through this charge, but you'll see some important pieces here. Affirmatively furthering fair housing, providing tools, clarity and certainty, reasonable frameworks, and ensuring state and local actions to meet housing needs. These are really the principles of the rulemaking advisory committee and how staff and the advisory committee kind of showed up and had discussions using this charge as really kind of that guiding light. So when we get to the second action that the commission will take at the end of this agenda item, we'll want to consider this rulemaking charge and how that can be amended in the future to further guide the work of 2025. All right. So the Oregon Housing Needs Analysis rulemaking process is kind of bunched into 3 different buckets. Needs and production related to things like implementing and integrating the Oregon Housing Needs Analysis framework as described in HB 2001 into the Goal 10 planning process. And housing acceleration is about that tracking and monitoring when we are measuring things like performance towards housing production targets. What does that actually mean, particularly when we've identified underperformance? And then thirdly, the capacity and urbanization. When we're talking about housing, we're also talking about urbanization. When we're talking about Goal 10, we're also talking about Goal 14. And those are kind of the universe of things that Land Conservation and Development Commission were charged with as part of HB 2001 to consider in this rulemaking process. However, we will be talking about only 2 of those 3 things today. All of the rulemaking that you see or the discussion that you see in the later part of this presentation is related to needs and production and housing acceleration. The commission will hear much more in 2025 related to the other the third piece here, capacity and urbanization, but this is due to the statutory deadlines by which commission is directed to adopt these particular sets of rules. So those first 2 that we'll talk about today required to be adopted before January 1st, 2025. The third one, we have an additional year to consider and bring back rules to the commission. So you won't see those until around this time next year. All right. So this is the part of the presentation where we get to kind of describe the work that's kind of gone into this entire process. And, you know, the engagement around this rulemaking is really pretty remarkable. And the folks to my right and the rest of the housing team, the consultant team, folks on the advisory committees and the folks who we engaged with throughout this process, just an absolute kind of inspiring amount of dedication and discipline and skills, and the countless hours that those folks have kind of put into this process is really pretty inspiring and remarkable. So kudos to all of those folks involved. But really, as you can see here, the advisory committees is just one piece of this process. The feedback that we hear throughout things like regional conversations, through holding open forums with local government partners, being invited to things like city councils and planning commissions and conferences, all of those conversations serve to inform the proposed rules in front of you today and are incredibly important to this work. So moving into the next phase here, which is the actual proposed rules themselves. And so when we're talking about these rules, we're talking specifically about Oregon Administrative Rules, Chapter 660, Division 8. The amendments to that particular division are yet again further bisected into or trisected into 3 rule sections related to the contextualized housing need, the housing production strategies, and housing acceleration program. And these graphics are pulled from that Goal 10 diagram that we showed in the beginning. And you'll see these kind of highlighted throughout the rest of the presentation, kind of orienting you again to where we're talking about specifically in that implementation of Goal 10. So we'll talk about each of these 3 sections in detail as we're moving through this next section. So first, the contextualized housing need. Commissioner Thompson, to your question, this is where the kind of ground truthing of the state allocation and state housing production targets in the local government context through the lens of affirmatively furthering fair housing. This section in particular is related to OAR 660 Division 8, Section 75. And if you're wanting to look at the rules specifically, you can take a look at Attachment A, and that's pages 9 through 13. So the contextualized housing need, right? We've spent a lot of time talking about that with the Rulemaking Advisory Committee and the Technical Advisory Committee, but it's not a new component of the Goal 10 planning process. This is an element of the housing production strategy work that was initially rules were initially adopted in 2021 related to the implementation of the housing production strategies. What I would describe this work is more of like an emphasis of that contextualized housing need. As local governments are going through identifying that housing need, the contextualized housing need is that kind of qualitative assessment of what is our future, what are our current and future needs, and how do we best set ourselves up to actually take actions to be responsive to that need. And one thing I wanted to point out here is that the contextualized housing need is, maybe one way to think about this is chapter 1 of both the housing production strategy and housing capacity analysis. It's the informational basis that serves both of those purposes. It is the identification of need, and then from there, local governments take the actions through the housing production strategy or the housing capacity analysis to be responsive to that need. So it is chapter 1 of both of those documents is maybe one way to think about it. So when we're going through these individual sections, DLCD received 109 pages of public comment as it relates to these rules. And as we're kind of thinking through amendments and the final revisions to these rules, one of the things we wanted to talk about is kind of summarizing the key themes of that public comment and the responsiveness and how that informed the amended version of the rules. So you'll see these throughout all 3 of the sections of rules. When it relates to the contextualized housing need, we really heard an amount of public comment related to this balance of certainty and flexibility. How does DLCD and LCDC adopt rules that address the obligations under House Bill 2001 and the Oregon Housing Needs Analysis, but also provide the flexibility at the local government level to work within the limitations and the constraints that they've got on the ground? Things like just staffing, things like the capacity of that staff to do the work, technical assistance grants, and data limitations in particular. Secondly, when commission's adopting rules, right? Those are static rules for the most part. And the data landscape when it comes to housing and housing production is constantly evolving. And there's investments being made at the state and local levels to ensure better and more effective data collection. And how do you write a set of rules that are static in that dynamic data environment that doesn't limit the ability of local governments to use additional data sources available to them in that process? And then finally, when data becomes available or is available at the local government level, and it varies across regions of the state, where Portland Metro might have more data available than, say, Eastern Oregon when it comes to housing production. How do you write rules that account for that availability and usability of data? So those are the kind of key themes of the comments that we heard in that process. And so that led to some of these key proposed changes, which are summarized here, and we'll go into those in a little bit more detail in the next slides. When it comes to the actual construction of the rules themselves, when it relates to the contextualized housing need, we've thought through kind of a reorganization of those rules to further identify, as you're a local government, as you're somebody who's reading these rules, you can read through them kind of sequentially or in a stepwise manner to make that more clear about what am I doing now and how does that inform the next step. And I think that serves really valuable kind of amendment to those rules. And when we're talking through the identification of housing need through the contextualized housing need, we're focusing on specific communities, those in particular being communities of color, low-income communities, people with disabilities, and tribal communities, not at the exclusion of other populations, but with a specific focus on these four. We also emphasize tribal coordination and consultation in the contextualized housing need, kind of looping back to the previous agenda item, and kind of leveraging the existing work that local governments are doing today already as they're doing things like climate-friendly and equitable communities implementation, making good on their federal obligations under the Fair Housing Act and community development block grants, and then thinking through a little bit and getting a little bit more clear on how local governments incorporate engagement feedback into those rules. All right, so let's dive into these a little bit more in more detail. In the contextualized housing need, there is a set of required analyses. There are three of them. The first being an affordability analysis. When we're looking at the actual market conditions that exist in that local government, what does it actually mean? How is the market responding to the housing needs of that community today? And how does that affect the provision of needed housing in the future? There's also an analysis of past discriminatory actions or practices as part of this contextualized housing need. We're taking a look at the historical inequities in those communities to not only identify those, but to understand how we can remedy and overcome and address those inequities in the future. And finally, an analysis of fair housing choice. As local governments are going through this process with, again, particular focus on those four focus communities, we're taking a look at the needs of those communities through kind of these 7 fair housing issue areas. And I've got those, it was a little busy on the first slide, so I've got those identified here on this slide, not necessarily to go through, but for your reference.
Commissioner Warren?
Can you go back to the previous slide, please, Ethan? Will you just walk me through what the review of market conditions actually looks like? Like what are cities supposed to measure there?
Chair Lova, Commissioner Warren, I'm actually going to hand that off to Celestina Teva.
Hello, everybody. Celestina Teva, she and they pronouns, housing planner with the department. So in the affordability analysis, the goal is to have an understanding of what the market is already providing and even potentially what, existing players in the nonprofit world, doesn't have to be only market rate, market development that's considered, but to take a look at the conditions that are in the community as it is in terms of housing production in order to then be able to incentivize or provide support wherever is needed. Of course, we know that generally the market is able to serve higher income households than it is lower income households, but a little bit more information, a little bit more granular, like what do we know about housing types, maybe by affordability, or what do we know about affordability comparing renter households versus owner occupied households. And really, I would say that at least the kind of the outcomes that might illustrate some of those market conditions, we know will be on the equity indicator dashboard. Preliminarily, this first rollout will have, kind of a base set of information, but we also anticipate that dashboard to be able to develop over time. And one data point, just kind of basic broad market dynamics, even average sales prices and average rental prices over time is a data point that we don't currently have kind of at a governmental level, but there's a lot of interest in. And that's kind of one of those nuggets of that Ethan was mentioning earlier about a dynamic data landscape where there is conversation about how do we get that kind of information at a statewide level and what do we have, what does assessors data offer, but that's not that's county specific. And so at this moment, there isn't a absolute specific definition of what exact market condition we're looking at. And that's partly because of this positioning of static rules and in that dynamic data landscape. Did that answer your question?
I mean, I think so, yeah. The answer is that we don't really know. We have an idea of what we think, but So what that tells me is that we can't hold cities to a standard that we don't really know about either. So my only suggestion is that as we go through this rulemaking process and we're looking at how these rules are playing out, that we adapt them to maybe define what we mean by market conditions as that data landscape becomes more clear, if it does. But I also want to just clarify that when we talk about market conditions, we're not talking about like material costs for building. We're not talking about labor costs. We're not talking necessarily about land costs. So that might be a good indicator of a market condition in the first place. Is that correct?
I think that's a great question. And I didn't mention it, but in the current analyses that include market conditions and kind of at least a rough affordability analysis that already occurs in the housing capacity analysis work. So even prior to the housing production strategy, the housing capacity analysis, which has existed for much longer, takes a look at housing need and has for a long time. And that has included kind of this market conditions look as well. And those trends are usually, from my experience, very broad, very high level, statewide, even national trends to understand inflation or increase of construction costs and how that might inform action selection. So I wouldn't say it excludes that, but I would say that at least with the current data landscape that we're used to, that those considerations are at a pretty broad level rather than a granular level.
Vice Chair Lazo.
Thank you, Chair. I just wanted to add to Commissioner Warren's a comment to Commissioner Warren's point that's well taken around the sense that in some of the rulemakings, we don't necessarily know exactly what a thing looks like when we're passing rules. And I'll say that that's actually not unique to the rulemaking that we're doing this afternoon. It's been true all morning and afternoon. An example is in the Goal 5 resources, we don't know what noticing requirements will look like. And so they're as we've called for in each of the rulemakings, these need to be iterative processes as we understand promising practices over time. I think here it's really critical as this programming rolls out that we do it sooner rather than later. And so I think that's something that we should discuss. But I just wanted to bring that forward also, that it's a good point and it holds true for all the rulemaking that we're doing. And we need to make sure we find those opportunities in each of these efforts to provide that support for our partners who are doing the work out there.
I don't want to have too much deliberation, but what's interesting in my practice is I'm realizing more and more that the market, before I used to be like, oh, the national is not really relevant to local. I'm seeing more and more that we're having a lot of similarities across completely different jurisdictions when it comes to market conditions, and the drivers are kind of the same at this moment, most of them. Commissioner Thompson.
I had a different point of view. I mean, I agree with all that's been said. My concern about asking about fair housing and how it plays out in rural is administrative capacity, because I hear again and again and again that the wealth to create administrative capacity is not, I would say, equitably distributed. And I wonder if there's a way that you're taking that into account, because you talked about what you did and when you did it, but you didn't talk about where you did it, or you didn't talk about the places out there. And I'm trying to help us think about how do we iterate realistically with what's available out there so that we really give that good support that I love to hear you refer to.
Yeah, I think that's your next slide.
Yes, Chair Lova. And really, just before we move on, one of the things that I think it's important to keep in mind is that when we're doing things like the contextualized housing need work, that's really for the purposes of leading into and identifying the need that local governments can actually take action on in their housing production strategy and in their housing capacity analysis. So when it comes to things like market conditions and at the national scale and things like material cost, when we're, that may lead to identification of a need, but it doesn't tie directly to things like action selection in a housing production strategy because it's not within the local government's control. So I just wanted to make that point. But Commissioner Thompson, to your point on how this is actually done. So there are those required analyses, but there's information that that can serve those analyses, that can serve to conduct those analyses, even if the local government doesn't have access to that data locally. And that's what you see here on number 2. So there are several data sets that the state is providing in terms of the housing production dashboard, things like the housing equity indicator dashboard. There are conversations that the local governments have with community members as another way to provide information, qualitative data to this process. And then there's kind of, to support that work, again, to kind of put that all in one place, we've actually added this piece of this state provided repository of this information. That's something that we're saying DLCD should host or provide access, easy access to this information when it comes to information that the state is providing that local governments can use. And so that really puts all of those pieces in the right place, and local governments, as they're going through this work, can look at one place and identify the information that they should be using in that process to conduct those required analyses.
Madam Chair, with respect,
Commissioner Thompson.
having the staff to do what you just described, that's what I'm talking about.
Sure.
Not that the data doesn't exist somewhere, but the staff to apply it, to gather it initially, and even if it's gathered somewhere else, how to use it. That's what I'm after.
Yeah, and we can talk more about that in our deliberation. Yeah.
Sure.
Unless if you have some comments during the presentation, do say.
Sure. I'll keep that in mind as I'm proceeding here. All right. And so there are bits of information, data sets that we know are available to lend themselves to this work. But there are other pieces of information that maybe the state doesn't collect, but the local government does. Or there are pieces of information that are available in some capacity that are not provided on that department repository or have not been updated at that point. But the rules don't preclude use of that additional supplemental, those supplemental data sets. And we kind of try to provide that opportunity by use of, as available, that kind of language, and recent within the last 5 years, kind of those points to say you can use this additional information. It's good information to use as part of this decision-making process. And when we're talking about the information that's provided on the department's repository, we're kind of deeming that these are available data sets and we should use those. And when outside of like the quantitative data environment, there's this qualitative element to this work, right? If we're doing that ground truthing, if we're trying to meet that housing need that's not showing up in actual data itself, there's opportunity and in fact obligations of local governments to have conversations with community members to further dive into the housing needs of particular communities, those communities of color, low-income populations, people with disabilities, and tribal communities. And the rules in front of you today kind of further clarify the expectations for that that equitable engagement that local governments are asked to do as part of this identification of needs process. Particularly that, and just kind of diving into that, particularly as it relates to the themes from that engagement. Local governments are responding at a thematic level to that feedback. So moving into the second of 3 buckets here, the housing production strategy. So as we're thinking about the implementation of Goal 10, right, we've got the first step done, the contextualized housing need. We've got the identification of need. We're moving into, we've done all that work and we know what our need is. And now we're moving into the actual actions portion, which is the housing production strategy.
Can I interrupt you for one
Yes,
second?
please.
The packet that we have in our hand is different than the one on the screen. So I'm not quite sure what to do.
Chair
in the
Levesque.
sense that there were extra slides that showed dashboards, which were awesome. Because I love dashboards.
Chair Levesque,
Just trying to how do we reconcile this?
You got a slide deck that included hidden slides
Oh,
from an old presentation. I apologize.
Okay.
Yeah. But those
I just wanted to
are
point that out if you're following along. Yes.
just sorry about that. So the just to, I guess we can touch on that real quick. Those are snapshots of and examples of the housing production dashboard of Oregon Housing Community Services and the equity indicators dashboard. Still worthwhile, to take a look at, but we're focusing on the actual rules themselves today.
Yeah, they're super cool. So
Yes, and yeah, and the commission saw those in October. I'm reminded. Thank you.
thank you.
Okay, apologize for that. The housing production strategy. So this is, you might remember, we kind of described this as like the game plan of the local governments to take those actions that promote housing production, affordability, and choice and meet that housing need that they've identified in their contextualized housing need. And the rules related to housing production strategy and what's included there are in section 200 of Division 8 and in the attachment pages 17 through 20. Very much like the contextualized housing need portion of the Goal 10 implementation, housing production strategies are yet not a new provision in Division 8 and its expansion of the existing housing production strategy framework. And in fact, HB 2001 centers the housing production strategy as the focus of Goal 10 implementation. Kind of using that game plan metaphor again, these are these identification of specific actions that local governments will take to directly respond to the needs that have been identified in the contextualized housing need portion of this work, and that will serve to meet things like the housing production target that are coming from the state or from the Department of Administrative Services. So the comments on the housing production strategy were related to, again, jurisdictional capacity to conduct this work, right? To Commissioner Thompson's point and others, there's a level of work here that is in addition to the work that local governments are doing under Goal 10 now. That is truth of the matter for this proposed set of rules. And how do we balance that? How do we ensure that what the obligations in front of local governments under House Bill 2001 can actually be acted upon? And especially when it comes to that conversation about capacity happens throughout the rules, but when it comes to the housing production strategy, particularly on the engagement side of things. When we're asking local governments to have engagement in a way that is actually going to be meaningful and lead to actual actions, that takes some effort and some work and some dedication to build those relationships, to have those conversations. And then also in the housing production strategy, in terms of that engagement, previously the rules talked about engagement with community members, kind of at the focus, but there was also some conversation and comment on producers of needed housing, the builders, the developers who are, providing the needed housing, and those folks, as we're talking about actions and facilitating or removing barriers and facilitating housing production, affordability, and choice, those producers of needed housing are critical partners as well. So we've emphasized the comments emphasize the need to engage producers of needed housing. And so that leads to these key proposed changes in summary. So again, specifying that engagement with producers of needed housing in tribal communities are part of the expectation for informing action selection in the housing production strategy. And looking into the kind of efficacy of the actions that are being proposed in the housing production strategy, kind of reorganizing that and putting that in a different in a different place on the timeline of the housing production strategy work and the kind of the action selection piece of the housing production strategy. And then kind of again on incorporating engagement feedback. What does that actually mean? Are local governments responding to every piece of feedback that they're receiving? And adding tribal communities to the folks who are who should be considered when local governments are making the assessment of how the strategies are going to benefit or burden particular portions of their community, and then kind of just doing some cleanup on duplicative requirements. So Jumping into these pieces here on equitable engagement, very similar to the contextualized housing need as we're engaging folks on the identification of needs. We're also engaging folks on the action selection, which actions are going to be responsive to the needs that they've identified or they've provided or articulated to the city, and kind of clarifying that response or the obligation or the expectation of local governments is that they're responding to that feedback at the thematic level. And they're also particularly engaging those producers, those developers, those builders when they are talking about the actions that they're actually identifying in their housing production strategy. The second, when it comes to actions, you've got a large universe in front of you in terms of the actions a local government could take. And we've got a list of over 100 of them on the that we're providing in terms of guidance and resources, but there's a refinement that local governments do, right? The universe is large, but in order to be responsive to the actual needs of that particular community, there's an assessment, there's an analysis, narrowing, a refinement that a local government does to identify the ones that are actually going to make the most sense for that local government. And in that analysis, there's an assessment of benefits and burdens. And when we talk about those focus communities, that's what we're talking about. That analysis of benefits and burdens should be with particular focus on communities of color, low-income populations, people with disabilities, and tribal communities. And local governments are also articulating those timelines, the steps in implementation, and how they are going to track the progression and the effectiveness of that particular action.
On a missing slide that we see that you didn't have in your presentation, it was talking about different tools. Unless did I mix? No, I think tools, resources, and assistance that are going to be provided. And I noticed the equitable engagement toolkit, which sounds awesome. And I brought this up last time, so I'm going to bring it up again about the people and planning document. Is that considered to be part of that, or something different?
Chair Love, I'll let Madi answer that question.
Chair Halova, Vice Chair Lazo, and members of the commission. For the record, my name is Mari Valencia Aguilar. I use she or they pronouns. Housing planner within division. Good afternoon. Great question about how the people in planning intersects with the resource that is under development, the equitable engagement toolkit. The quick answer to your question is yes. So the consultant team that we've been working with, Multicultural Collaborative and Not Studio, thank you, in building out that equitable engagement toolkit, they used and pulled the universe of existing resources relative to equitable engagement, including that people in planning, putting the people in planning resource. So that is a considered element that is informing what you'll soon see in terms of the equitable engagement toolkit when that becomes available.
Sort of in the group of don't everybody doesn't have to reinvent the wheel. Like, here's a resource that you can pick and choose. I don't know how many of you seen that document, but it's pretty awesome. It's like, let me get a copy because I'm so into it. It's basically allows to be like, if you want to try to do this, there's all these different, this is good for that, this is not good for that. So you just kind of pick and choose based on the kind of outreach you want to do, Commissioner Boyer.
So you'd mentioned that there's a document of 100 suggestions. Can you dive into that a little bit, please?
Absolutely. Chair Lova, Commissioner Boyer, call that kind of the list of tools, actions, and policies to be, it's not I'll describe it as kind of like a menu of options. Here are the things that, as we were working as chair and DLCD and others were working on the housing production strategy rules, kind of the last go round, there was a lot of questions about, okay, you're asking us to consider these strategies, these actions. Could you give us some examples? And so we kind of did this crowdsourced opportunity of everybody could kind of put all of their ideas on that in that list, and we kind of warehouse it on the DLCD website for any city to kind of have access to and give them, get the gears turning a little bit.
This is my
jumpstart them.
database, the thing I'm always trying to
Yes.
talk about.
That's a lot, 100 suggestions. I mean,
So
that's
essentially,
amazing.
I crowdsourced it with
Yeah.
everybody I knew who knew anything about affordable housing developers, middle housing developers, everyone. Can you give me some rural folks? Like literally crowdsourced it, and then started to categorize it based on like these buckets. And my fear at the time, because I was on the Rules Advisory Committee, was that all the strategies that would be thought of were going to be zoning. And that's just one slice of the pie for housing production. And so essentially they're categorized. I don't have the list, but some are zoning, some are like tax or, kind of incentives. Some are like ideas for public-private partnerships. And then there were quite a few, not quite a few. There was a couple that were in there that had a little asterisk that says this does not exist in the state of Oregon, but it could, just because there were some really great ideas that would be awesome, but we don't want to get anybody the idea like, oh, where's that program? And then it's not there. And so, and then it was categorized by like, is this good for 0 to 30% AMI or 60 to 80? Like, what is this good for? And then it was also categorized by, is this good for rental or is this good for homeownership or both? And then layered on top of that was the gentrification and displacement toolkit that said, this would be great for an area that's starting gentrifying, an area that's rapidly gentrifying versus this is good for an area that's like more stable and not changing as much. And so this is the thing I've been talking about all the time, because right now it's a PDF. Right. Awesome list in PDF. What I would like is this to be a database where a city could say, we need, after we do our needs analysis, they realize we need 0 to 30% MI, and our community is really saying homeownership is what we need. And you could like literally sort for that, and it would kind of lay out, here's 10 different strategies. And the idea for the database really was about, as cities roll out their own versions of this, then it could be put into the database as another resource, because for each of it says like, where's there an example of this? And it says like, they did it over here, or look at this report. So I saw it as a living, without it becoming a database, it's not living, and people could then contribute to it and know that it's there. And part of my frustration that I've said many times, sorry to get on my soapbox, is that there's so many different efforts all around to come up with the same thing. And I'm like, we have 100, I didn't know it was 100 strategies. Let's take those and add them, and not do like, somebody should be able to look through them and go like, oh, I'm not going to invest in that. It's already on the list. I'm going to think of something different. So in some ideal world, we'd start to understand which ones are good for coastal communities, which goods are good for more rural or Eastern Oregon, if we had a database that kind of was responsive to that. So that's my big thing that I would like to see before I leave commission a year and some months away from now. Yeah, because it's a huge resource is the idea.
Yeah.
To be fair, it's an Excel. To be fair, it's an Excel spreadsheet.
It's an Excel spreadsheet. It's Excel.
Also PDF.
Yeah, an Excel into a PDF.
Yes. Yeah. Right. Chair Lova, Commissioner
Yeah.
Boyer, maybe.
Commissioner Thompson wants to.
Oh, sorry.
Is AI in our future? No, I'm serious.
Yeah, that is a thing.
I think there's a connection here that I just want to make real quick to the second agenda, or the second task that we've got in front of you today, which is related to the Housing Actions Work Group in the work of the Rulemaking Advisory Committee in 2025 that I'll try to loop back to when we get to that point. All right, proceeding here into the Housing Acceleration Program, which is the
Vice Chair.
Yes, please.
Before you go to the next deep thinking chair and the next deep blue slide, I have a question on the engagement piece. There's a shift in the engagement. We have this focus on some communities, and instead of asking cities to go out and try to engage with those communities, they have the opportunity to do that directly. But one of the opportunities we have for cities to do that is also to engage with producers of housing that serve those communities, right? That sounds like that's a change to this piece of it that provides some efficiencies in the way we do this. And again, I think you noted in the staff report, not only does it provide an efficiency in how we make contact with communities, but reduces what we heard pretty regularly in the RAC around engagement fatigue from those particular communities, which is very real. So yeah, I just wanted to see if you could highlight, is that the way that piece is supposed to work? Because I didn't actually catch that change before.
Chair Halova, Vice Chair Lazo, thank you for the question. And you're 100% correct. The equitable engagement rules changed to kind of informed from the discussion that you all had at your public comment or the public hearing in October, where you heard public comment saying the realities of local governments experiencing capacity challenges, resource challenges, and even being sensitive to wanting to do equitable engagement, but recognizing that, you know, we're tapping a lot of folks and they might, you know, be fatigued. And you all had a great discussion about contextualized housing need in terms of understanding that, which is the point in time in the HPS program where local governments are understanding what their current and future needs are, engaging communities for that particular point in time is important. And then at the action selection phase of the housing production strategy, maybe doing a more focused engagement on producers of housing that focus specifically with those 4 named communities that we've been talking about. So that'd be communities of color, low-income communities, tribal communities, and people with disabilities. So that is kind of a shift and trying to, you know, address the capacity concerns that we've been hearing at the local government level.
It's a huge deal, because those producers of that housing specific for any of those communities know all the things. They're just waiting to tell them to somebody in the sense, and they're motivated, right, to make those changes because that's going to help produce more housing, right? So that's really good because that's a frustrating point to come to community with specific technical, like, how do we produce this housing? It's like, that's, you know, the community is really about like, where's the need? And then like, you have to talk to the producers to be like, you know, especially the ones that care about whatever need it is. So it's huge. Yeah.
You know, to make a quick point, especially considering our previous agenda item about tribal consultation, we're also requiring that we notice tribes as part of this equitable engagement. Is that correct?
Chair Halava, Commissioner Warren, yes. So under Deputy Director Green's tribal liaison leadership, I conducted outreach, consultation, and coordination with the tribes during this ONO rulemaking. And with the 7 of the 9 tribes that we heard back from, there was unanimous interest in being notified and having an opportunity to consult and coordinate.
There's also opportunities I've heard for funding that would typically go to tribal nations in reservations that can actually be applied to in cities to create housing within, not within the tribal communities, but for tribal communities. Yeah.
All right. Bucket number 3, which is the housing acceleration program. So when we're talking about, we've kind of progressed through these 3 sections at this point. You identify the need, you take the actions, and the housing acceleration program is that tracking and monitoring and course correction element to this goal 10 implementation system. And the key point here on this housing acceleration program is it's set up to be a partnership between state and local governments to overcome those barriers that are leading to underperformance or not making progress towards those housing production targets. And for the OER citation, it is section 300 in division 8, and the attachment, it is on pages 23 through 37. So kind of stated a little bit differently, I guess, or a different way, for local governments that are falling behind, the acceleration program helps the state come to assist local governments in overcoming those hurdles to housing production, affordability, and choice goals. The housing acceleration program is kind of like a 4-step process, and they go sequentially for the most part. Referral and determining which jurisdictions are eligible and are referred into the acceleration program. An assessment or audit of the barriers at the local government level by DLCD. Entering into a housing acceleration agreement, which identifies the course corrective actions. And then finally, the step we hope we all never get to is mediation and enforcement. public comment related
Commissioner
to,
Boyer has a question.
yes.
Quick question on that slide. So the help that DLCD gives, is it technical or is there financial support?
Chair Lova, Commissioner Boyer, both.
Okay, thank you.
All right. When it comes to the housing acceleration program, the public comments or the comments that we received kind of centered around these issues, which is how can we better clarify what it means for local governments to be compared to their peers? That's not the same as being compared to the region, but being compared to market peers, housing markets that are similar to that particular jurisdiction. As part of the housing acceleration program, as we're asking local governments to coordinate and consult with tribal communities, there is a thought that DLCD should also have that same expectation as part of this housing acceleration program. And then in terms of when we're measuring progress, public comments wanted to ensure that we're talking about, in particular, paying particular attention to housing at targeted income levels, particularly low, very low, and extremely low income levels. And then kind of these last two being about the actual tools available and the state intervention that DLCD would both provide and administer as part of the housing acceleration program. When it comes to using those tools, the public comment was centered around that those tools in terms of enforcement, technical resources, financial resources should really be towards particular outcomes, things like fair housing and overcoming those particular barriers. And then finally, when we're talking about accountability enforcement, use of those tools should be taken into special consideration and not, really jumping in headfirst immediately into state intervention into local government matters. So here are the key proposed changes to the housing acceleration program rules as in summary. So we've kind of taken those public comments and incorporated, for the most part, all of those comments into the rules and the proposed rules here. So refining consideration of underproduction and what it means to underproduce at those lower income levels and how that factors into the referral decisions. Clarifying how the state would determine those comparators, those peer comparators, and introducing kind of a more clear process on how the state prioritizes resources and support to local governments. And finally, adding a portion of this housing acceleration program where DLCD would engage with tribal communities as part of that audit process and consider that in that decision-making process. And also some cleaning up of some duplicative requirements across the board. So when it comes to the referral portion, the referral step of the housing acceleration program, this is that first step in the housing acceleration program. When looking at jurisdictions who are kind of in that point of their housing production strategy process, there's an assessment that the department will make to determine which jurisdictions are both eligible for referral, those being jurisdictions performing at 50% or below of their market, or sorry, their peers and their region, and then a further prioritization of those jurisdictions who are eligible for referral that will actually be referred. So you start broad and you narrow based on the kind of most outstanding issues. And to inform that process, there's an amendment to the rule or a change to the rule that would prioritize jurisdictions for referral that are underproducing housing for communities making 80% of the average median income. When it comes to the comparison, how jurisdictions and which jurisdictions cities being compared to, there was a couple questions in there about both the timing and what happens when there's no comparator or no peers. So when it comes to timing, the housing production targets are published on an annual basis. Cities are conducting housing production strategies and housing capacity analyses at different times and on different cycles. And so kind of the housing or the peer group that sticks is the year in which jurisdictions are completing their housing capacity analysis and receiving their housing production target. So it's kind of all locked in at that one time. So it's not changing throughout the entirety of the process. And local governments can have some certainty on who they're being compared to and what their housing production target is. And then finally, in conversations in the technical advisory committee about some of these jurisdictions who are starting this work for the first time, things like metro counties, and having like, how do you compare metro county to peers across the state? There's not a really good comparison there. So in the absence of having those peers, in the rules, we've made it clear that those jurisdictions would just be compared to the region that they find themselves in. And then finally, there's a consideration here about how you're accelerating production, right? If you're making incremental annual progress year over year and you're accelerating that production, we should take that into account as part of this referral process. And so we've clarified that in rule. So once we get to that next step in the housing acceleration program related to the audit of local barriers, remember this is DLCD auditing or assessing the factors at the local government level of local governments who are have been referred into the acceleration program. We made more clear the factors that the local government will actually, or sorry, the department will prioritize in that audit. Specifically focusing on barriers to fair housing choice, inclusion of adoption-ready actions in a local government's housing production strategy, the work that local government is doing to comply with climate-friendly areas and housing production in those climate-friendly areas, and then again, kind of considering that acceleration of production. And then, like I've mentioned, in that audit, DLCD will consult and coordinate with the tribal communities in that jurisdiction's particular region. I wanted to pause there yet again on housing acceleration. If there's any questions, Chair.
We've hit our time for the presentation, but we've
Okay.
also been asking questions. So I'm
Yes.
considering that part of our question period. So
Okay.
it's a good way to ask questions so we don't save them all.
Yes. And we'll move into this last piece here. So in addition to those three buckets, there are some other classify these as like more miscellaneous amendments to the rules that since the commission has seen them in October. In particular related to definitions, some fine tuning and tweaking of language around these particular set of definitions. And those are identified in attachment A of your packet if you're interested in those particular definitions, but they are summarized here. The second is related to the deadlines by which local governments are required to complete their housing capacity analyses and housing production strategies. This is an existing section of rule. We've just made some clarifications based on some learnings from the first round of housing production strategies and some of the conversations that we've had with the advisory committees, particularly as it relates to the housing production target and when that kind of, again, sticks for that local government. And so, like I've mentioned previously, that housing production target in that particular year is tied to the year in which the local government is adopting their housing capacity analysis. So that is the number that sticks with them throughout that planning cycle. And then some kind of discussion that we've had with the advisory committee and just internally about what is the mechanism by which local governments actually complete or, say that they're done with their housing production strategy, and just kind of clarifying that local governments can adopt their housing production strategy by resolution. Okay, and then in terms of reviewing the contextualized housing need, there were some questions about just the timing of this, right? If it's informing both the housing capacity analysis and the housing production strategy work, how does that review, or how does the local government know with certainty that that work of the contextualized housing need is done to the level of expectations or requirements established by the rules? And so we've kind of considered some adoption pathways here, right? As part of a housing capacity analysis, we know that local governments are adopting those through a legislative process, a legislative amendment to the comprehensive plan at the local government level. So there is a true bona fide adoption of that contextualized housing need at that time. That's one option. Another option is through the sequential UGB process, which local governments are using to kind of go through this process in a more sequential manner. And that is yet another option. And then kind of a opportunity for that local government to request DLCD review of that contextualized housing need as part of the housing production strategy. So just making those options clear in the rule. And then finally, on midpoint reporting. So this is the point either 3 years in for a local government in the metro boundary and their 6-year cycle, or at the 4-year mark in an 8-year cycle for jurisdictions outside of the Portland Metro. Just kind of clarifying some of those reporting requirements and the timing of that midpoint report. So some of the climate-friendly and equitable communities rulemaking kind of tied the scope of that reporting to the midpoint review. And so we're just kind of making those clarifying amendments and then identifying a particular submittal date for that midpoint report on May 1st, which has the effect of shortening DLCD's review, but does not shorten the time window for local governments to submit that report. And finally, when we're talking about the midpoint report, it's a narrative reporting element that local governments are submitting to the department. And in that analysis, there's an assessment of fair housing issues that might exist in the local government. And if a local government is portraying that they do not have fair housing or disparate housing impact, they have to kind of show that they can identify that and provide analysis that supports that finding as part of that midpoint report. So at long last, we're at the mint green slides, which I do want to kind of point your attention to something that I think you have at your seats, which is Exhibit 1 here. So in our final reviews and combing through the rules, we've identified 3 technical fixes to the rules that we would like you to consider as part of your adoption today. These are items that either are correcting errors or making more specific the intention of these 2 definitions. So I'm hoping that everybody has Exhibit 1 in front of them. I'll summarize them really, really quickly. The first is just a correction to a citation that was made in error. And the last 2 are broadening the applicability of those definitions to the state building code and kind of referencing the state building code rather than one element of the state building code, the Oregon structural specialty code. So technical fixes to those proposed rules that we hope you will consider as part of the recommended motion. So Chair Lova, happy to answer any clarifying questions.
Commissioners, any questions? Clarifying? Commissioner Warren.
So going back to the contextualized housing need, can you talk to me more about how cities are expected to analyze wealth building opportunities, please?
Chair Halava, Commissioner Warren, thank you for the question. Much appreciated. In affirmatively furthering fair housing, one of the ways you can do analysis for housing choice is based on looking at disparate outcomes. So when I think of that particular analysis area, that's probably where I would start. I will add that we haven't developed all of the guidance for all of these rules just yet. So I can give you some of the things that, we've discussed and are familiar with this at this stage, but it probably won't be exhaustive. But for that example, for taking a look at disparate outcomes to kind of back into barriers to fair housing choice, we could look at disparities in tenure across those focus communities, right? Communities of color, people with disabilities.
You're saying ownership when you say tenure.
Yes. So most commonly we understand tenure, and most of our data supports tenure at that binary, that home ownership versus rental level. We do know that there's more and more interest in development and access to various types of home ownership that don't quite fit in that binary, but generally those are the things that we're talking about when we say tenure. So that's one approach that comes to mind. There's also the qualitative approach that we've discussed and have been preparing to develop guidance for, which is taking those opportunities when we connect with community to ask really pointed questions about choice, really pointed questions about, do you live in the neighborhood that you would like to live in? Or would you like to own? And if so, do you? And if not, what would you attribute that challenge to, or that barrier to be? So those are just a couple of the types of analyses or investigations for fair housing choice.
And Commissioner Warren, these questions that were on that sheet that was like, I'd have to flip. Let me find them. There was a series of the seven questions. They, tell me if I'm wrong, but I'm quite sure I'm right. They were part of the 2019 rulemaking that we did. Cities had to answer those questions, and it was written differently at the time. It was home ownership and rental housing. It was very specific home ownership to create wealth. So because of that, cities have had to do that. It's just now in a different labeling and bucket. Am I correct with saying that?
Pretty much, yeah. There's a section in the current Division 8 rules called, I believe, Achieving Fair and Equitable Housing Outcomes. And there are 6 subsections there. And one of those is, or I think they actually are separated there. There's one that says rental and there's one that says home ownership. And yeah, I would say actually in our conversation about specificity, the rules that you have before you today are more specific about really what we're looking for than those 2019 rules that kind of named those interest areas.
That's sort of like the evolution of rules is like they were established in 2019 and now they're wrapped into a new subset. So I would say that's definitely an evolution as we've been talking about evolutions. Commissioner Thompson.
Express it in the North Coast. Astoria is the only place. There are no comparators. Okay. I think about the flow of people who live in Astoria, the lower income, the people who would qualify for housing, they move to Warrenton. If they lived in Cannon Beach, they move south into Tillamook County. I mean, there has been this flow over time. So if you say we want to talk to community members, they're gone. They're not there anymore. So I'm trying to wrestle with how do we establish or reestablish a vital community that provides opportunity that may not fit into the paradigm that I see described here. And I don't even know if that's a question. I don't want to derail this process, but I'm trying to match up my reality with what you're telling me, and it doesn't always fit.
I was going to, before you answer the specifics, that was part of the discussion of going to this ONA was that housing is not a city specific thing. It's a like a watershed. I don't know what you call it, housing shed. Because of expensiveness in this area, right? You're going there, but you actually want to live there, but you don't have the opportunity. So that's an interesting question in the sense of, we were talking about distribution of housing need across. Sorry, I have so many thoughts. Let me think about this for a second. One of the greatest things that came out, like these light bulb moments, was really something Sean Edging said when we were starting this ONA process about how the system works now being before ONA. And it was a huge light bulb, like where you're like, oh, the way that we're thinking about allocation of housing need is based on past practices, which the past practice would say Astoria doesn't need any affordable housing, right? It doesn't have any, I'm exaggerating, right? It doesn't have any now, it doesn't need any in the future, right? And you're like, wait, that doesn't make sense. And so this idea of going to a statewide look, thinking of housing sheds, I'm going to call it, really broke through that kind of systemic issue that exists before. And I was actually going to relate that to what cities are going to do when they start looking at this. They're going to release their own light bulbs. They're like, wait, what? This doesn't make sense. Just by the mere act of investigating, you find out things. but I want to go back to your question, which was, given that condition, how do you do outreach in thinking about the people that might not even be there?
Well, and the
Right.
second part of that is, if I could please, because I agree with everything you said, the jobs aren't where the housing is. And for me, that's the biggest problem. When you talk about healthcare, it's like, wait a minute, it doesn't fit together.
Yeah, Chair Lova and Commissioner Thompson, I think Chair Lova's points are kind of spot on here in terms of there's the data piece about the realities of, there are other elements of housing need, and like housing markets don't just stop at UGBs or city lines. What happens in Astoria impacts Warrenton and vice versa. And so we should be thinking about those housing markets as these kind of regional, groups. And we can then from there determine things like provide this allocation that considers things like the impact of second vacation homes. It considers things like where jobs are, and those are elements of that date, like true data piece. And then, but that doesn't provide the whole picture, right? So that identification of need is both that quantitative data, like hard numbers kind of situation, and it is the conversations that local governments are having with community members. Now, the actual act of doing that engagement and having those conversations is not always easy in terms of those, where are the people, how do you get to the people to have those conversations? Are they in Warrenton or are they in Astoria even? But the obligation is to seek that out, right? Because the data does not alone provide us with that clear picture. It's only a piece of the puzzle. And you need to bring that other piece to the fold. And there are resources that, things like the equitable engagement toolkit that chairs talked about, that putting the people in planning that serve to provide, something that local governments can use, those actual staff can use as they're, considering how they might reach out to those folks. There's data included in there, we can talk about that engagement toolkit when it's complete and ready for your review. But there are pieces in there that support local governments in doing that difficult work of having those conversations.
I could add, Chair Halava and Commissioner Thompson, just in terms of the rules in front of you today, the term community members of needed housing has a definition that we toiled over for this reason exactly. Do we name individuals who live in the city, who live and work in the city? How, what about folks who are no longer at working age or don't work? But, there's so many challenges to creating that definition discreetly and also inclusively. The definition that we have in these rules is any individuals who inhabit or are anticipated to inhabit needed housing. So may not be perfect, but was intended to account for folks who might be expected to live in the community but don't, or even thinking ahead into our future about folks we may need to be planning for accommodating. So it is not as explicit to your particular point, but we did attempt to allow some flexibility for local governments who know that there's a community who maybe doesn't currently live but should be communicated with.
This is a really, I don't know if it's specific or not. This is the one thing I'm like waiting for. I would love for it to just play out just to see how this thing plays out, which is what happens when the cities do all their thing, everybody's done all their stuff. But at the end of the day, we realize that housing's not happening in a certain community because lenders won't lend to that community. Because that's a real thing. I know for a fact. What does that, who does that trigger to act? Because that's nothing we can do yet. Nobody's given us that authority yet. Yeah. What happens if everything's in place, everything's wonderful, except no lenders will lend here?
Chair Halava, for the record, Thea Croman, I'm a housing planner with the department. Thanks for the question. This is a moment when the housing acceleration can step in and is and DLCD is actually authorized to sort of take a mediation role to work with known lenders to try to connect lenders with the particular community. So what that looks like, yet to be developed, but there's a very specific role for the state to actually make that connection happen in a way that communities themselves cannot be expected to do, and applicants and developers tend to not be able to do either. So it's a kind of convening role that the department will step into.
It would be lovely, I don't know how, to start that convening today. Because I've talked with folks that we're like, we should just get, specifically on the homeownership, we should just get like 4 or 5 banks that are really interested in this topic and see, like, banks, what are your problems? What do you need solved actually to be able to lend in this situation? So yeah, I've already been in a kind of we should do this mode, but that is specific to homeownership in the city of Portland. That's not a totally different jurisdiction, which they would say completely different things. I mean, it might be completely different banks, actually. So the role of the lender is huge. I mean, I've said this many times, like when I think of like what's preventing me right now from doing rental housing, affordable rental housing. Well, I won't talk about affordable for a second. Rental housing, I think construction costs, I think insurance, I think interest rates, I think available lender. Those are the first things that come to my mind personally, not zoning, Not that this is huge, right? Because we don't want this to be an impediment, but that's my sort of thing is like, we do everything we're supposed to do, which I believe we are. And then we get to that point and it's those things, then how does the state help to alleviate those things? Obviously, I know the construction cost is, I have a lot of thoughts on how that could be helped, but yeah. I'm excited. I did not realize that was part of the acceleration program. It's very exciting. All right, I'm so excited. I don't even know where we are on the agenda. Any other commissioners? Any questions? If not, we might ask for a motion. Oh, no, Vice Chair Lazo as the commission liaison.
Thank you, Chair. I'm glad you didn't overlook that because I took the opportunity to write down a few notes since I've been involved in this work for several years now, and it's so near and dear to my heart. I'll go back to something that I've said about this work at the highest level, and I think it comes through in the way that we all talk about this work. We recognize that everywhere in the state is in a housing crisis right now. We also know that everyone in the state has a part to play in solving that crisis. And the piece that is in front of us today is the part that we play as a commission, and as an agency. It's also the piece that has been asked of us specifically by the legislature. Right. So this long effort that has been taking place over the last several years, what's in front of us today are the final pieces that we are going to carry across the finish line. And it really includes this 3-legged stool around moving the best way forward around all 3 of the elements of production, affordability, and choice. And, I don't think we're going to get every one of those right. And so that iterative process that we talked about is going to be vitally important to make sure that 3-legged stool continues to stand over the next few years. But we really need to move it forward in that way. There are going to be pieces of this that we don't agree with, but they're all critically important to making the program work. As we've heard, much of what is in the program right now, as proposed to us today, are pieces that were in the 2019 rules. So much of it has been repackaged, kind of reorganized in a way that I'll have to say, as I've said over the years, I continue to be impressed at every mark to, the next piece we get to. I did that when Sean was doing the work, when you all have been doing this work, and where we are today is again, another leaps and bounds above where we are organizationally, I think, right? I think it's easy to understand what we're trying to accomplish here. So if we did nothing today, much of what's being asked of cities will be on the table from the 2019 rules. So, but it also does further recognize, as you've seen in the response to the public comments that have come in, that there are capacity issues, there are pressures on our partners that experience a great deal of issues around budgets, around the shifting regulations they're being asked to comply with. And so it really does also emphasize this framework in the agency around partnership and support. We know that not only is that going to have to happen inside the agency with the work that you're doing, as Ethan said, it also includes money, which also means it also has to spread beyond the agency to the governor, to the legislature, to continue to make those commitments, not just, again, on the one leg of production, but on all three legs of production, affordability, and choice. Those are pieces we don't control, but they're critical to making this program work. And I think the work that you all have done really worked very hard to find that balance around flexibility and state level resources, all those pieces that it's going to take to make this work. And I'm so appreciative of where we've gotten to and really looking forward to this program being on its way. That said, it's also critically important for us to reiterate back through this, just as we've done with things like the community or the CFEC, the climate friendly and equitable communities rules. And again, as I said earlier, sooner rather than later, so that we can hear from our partners about what's working, what's not working. We know that they've expressed some fears to us about what it's going to take to move this program forward. And we ought to find out pretty quickly from them whether or not those fears are coming true. So, again, I think there's something in this programming for every community. And I think we do a real service to it by supporting it and helping it move forward in a way that sends the message that we are doing our piece to move this crisis forward, or to move beyond the crisis that's in front of us. And I think that this work is that piece. Thank you.
Thank you. Thank you for your words. With that, maybe you'd like to make a motion? I want to make the motion. Nobody's letting me do that.
I will, as long as
Put it on the screen. Here, read that.
I will say, though, that we actually didn't get Exhibit 1 in our handouts, but it's online. So I move the commission adopt amendments to the Oregon Administrative Rules, Chapter 660, Division 8, as recommended by the department and shown in Attachment A and amended by Exhibit 1 with the following changes that are outlined in Exhibit 1.
Would anybody like to second?
I'll second.
So with that, the motion was made by Vice Chair Lazo and seconded by Commissioner Warren. Would we like to do the roll call?
Sorry.
Do I need to do something? Did I miss something?
Just to clarify, in our Exhibit 1, where it says the housing capacity analysis definition, it's actually section 21 in the new rule. It's listed as 17. I don't think anybody get confused by that. I just want to clean it up before we vote.
Entertain a friendly amendment from Mr. Shears.
Just and Chair, may I say one more
You
thing?
does somebody have to say something over again?
Nope.
Okay. Commissioner Warren?
I just want to say one more thing. I can't get past the fact that I do feel like this is a significant burden on a lot of our partners. By passing this today, we're creating a significant amount of process in which planners around the state will have to go through in order to start planning for housing. Not to say that housing planning is already not happening. A lot of cities are doing amazing work without these rules in place. And I just want to emphasize that I know that that's happening. And we see these cities doing the work already. And so that's great. And I can't move past this agenda item without we need to recognize that in the work that we're doing right now. And a lot of our partners are having some significant financial challenges right now around the state. I mean, their budgets are not in a good place. I mean, a local city that I'm aware of, who you all probably know who I'm talking about, I mean, it's facing a $20 million budget deficit right now, right? And that doesn't look like, okay, what do we do? That looks like staffing cut it across the city. And so we just have to keep that in mind when we're making rules like this, that we have to be very, very aware of what it's going to take for our local partners to do this work. And I think you have, to the extent you're able to, with the statutory requirements.
Commissioner Thompson?
Amen to what my colleague just said. My trust in you all and us is that this iterative process that we have committed to today will involve ground truthing about those facts, those realities, and it will inform what we do going forward. So I trust us for that because I see nodding heads and I believe you. Thank you.
Yeah, and part of that is what we did in other rulemaking where we are like sort of jointly committed to bringing any awareness that we have toward folks that might be able to fund grants to local jurisdictions or as extra support from our side. So that's something I've been, if we hear a need, we keep passing that along as we go through these process. Commissioner Bennett.
Yes, I really wanted to join in with Commissioner Warren and Commissioners Thompson in speaking with the cities on the east side. They've really said, we're down staff. We don't have the funds to compete for staff, and now we're going to have our budgets cut. But I place a lot of hope in the staff report where it says balancing consistency with flexibility, and that a lot of effort and emphasis is going to have to be on that word of flexibility, because otherwise the local partners are just going to tilt, and that's going to be a tragedy, and we're going to be perhaps in a worse spot than we are right now with a lot of them, where they're just going, we can't do it. So I support the work, obviously, but I really have hung a lot on the flexibility, and I'm sure that Director Bateman has really demonstrated that consistently with her staff and crew there, and so I'm proud to be part of it.
Thank you. I have so many thoughts. I mean, one of them was as more housing is produced, that's, depending on SDC waivers or not, that's more SDC waivers, that's more tax revenue based, that's, and how that plays into helping cities attracting jobs because you have housing. And I just the role of housing and so many other economic development factors is huge. And the choices that companies make on where to locate or not to locate, like it has, a lot of times we focus on housing just for the people who are living in the housing. And I'm like, I feel like it has so much more range than that. So I'm excited about more housing. Okay. I think we had a motion and a second. I think we're ready to do the roll, but thank you for those comments. Yes, please call the roll.
Commissioner Bennett,
Aye.
Commissioner Porter,
Aye.
Commissioner Thompson,
Aye.
Commissioner Warren,
Aye.
Vice Chair Lazo,
Aye.
and Chair Halova.
Aye. And with that, the motion passes on the ONA. And we have another piece of ONA, which is this 2025 ONA rulemaking scope. So talking about the next iteration, here we are.
Yeah.
This is a much shorter presentation, and so.
Chair Liva, we're almost done, but not quite. And that's the same for the rulemaking, actually. So the rules you've just adopted are the first, I'll call them tranche of rules. The work continues, however. Like we mentioned in the beginning of this presentation, there are three portions of Oregon Housing Needs Analysis rulemaking that LCDC is directed to conduct. And the kind of last bucket here, the capacity and urbanization work, has a statutory deadline of those rules being adopted by January 1st of 2026. The work of that technical advisory committee and the rulemaking advisory committee continues into 2025. And just a quick reminder on the scope of the capacity and urbanization technical advisory committee is they are developing really kind of focusing in on providing clarity and certainty in the intersection between Goal 10 housing planning and Goal 14 urbanization work, particularly as it relates to things called development ready lands inventory and fixing this issue that's kind of been coined as phantom capacity in the buildable lands inventory process. And a major portion of that work is thinking about this bigger picture of housing planning and public facilities planning, and how do those be coordinated in a way that as we're striving to meet these housing production targets, one of the key pieces to meeting that housing production target is the facility or the provision of public facilities. And how do we do that planning a little bit more coordinated and concretely? There's also this other element of the rulemaking scope for 2025, which is known as the Housing Actions Work Group. This work group is tasked with thinking through the adoption-ready actions that were included in the proposed rules in front of you today. These are things like the particular actions that a local government may consider as part of their housing production strategy when they're doing that action selection, and potentially even informing the work of local governments as they're going through that identification of needs process. The Housing Actions Work Group will also focus on building out that suite of guidance and those resources, and maybe even that dashboard, Chair Lova, and thinking through things like a model code that's been directed under Senate Bill 1564 from the 2024 session. So I wanted to pull up this timeline a little bit and show, this is an intentional point in the rulemaking process, right? We've adopted rules that kind of are filling out the framework for things like the contextualized housing need, the housing production strategy, and the housing acceleration program. And those rules now exist, and local governments can begin to wrap their heads around what that means and start planning for that process. Things like the equity indicators dashboard and the housing production dashboard will be published on January 1st. And so all of these things are building towards the full rollout and implementation of the Oregon Housing Needs Analysis Program under Goal 10. But the work, the other pieces of that diagram, the housing capacity analysis and what it means for local governments to actually identify those actions, is the work of 2025. And so kind of finishing out that the touch points on each of those pieces of the diagram.
That's a question that you may be able to answer or not. Are there any of the POPs? Are they considered POPs in this related to any of this work? The ones that are in the. Okay. It's like not yet it's not a thing yet, but I just curious.
Director Bateman, if you. I'm inviting Aurora Jettle to the testimony table.
POPs mean policy option package.
Yes. For the record, my name is Aurora Jettle, legislative and policy analyst with the department. Thanks for the question. Yes, there is a policy option package that was included in the agency request budget for an additional $1.7 million related to ONA work. That's $200,000 to continue the housing action work group that you see on the slide, and then adding an additional $1.5 million for grants to local communities. And that has been moved forward in the governor's recommended budget.
To know. Thank you.
Thank you for the question, Chair. Okay, a little bit more detail on the Housing Actions Work Group and how this kind of ties back into the second action that we're asking you to take, which is an amendment to the rulemaking charge. In the rulemaking process throughout 2024, the conversation related to both the contextualized housing need and the housing production strategy and the housing acceleration program kind of spanned all three of those elements. We're trying to think through, standardizing these pathways, right? When we talk about flexibility, there is a point where there is too much flexibility, which leads to no expectations and no clear path forward. And so how do we, there was a conversation in the Rulemaking Advisory Committee about maybe there are elements of this work that would benefit from a standardized pathway. And particularly when we're talking about things like safe harbors, optional things that if a local government does this thing, they are achieving this kind of compliance safety. And then even considering things like minimum requirements, things that every local government is required to do as part of that work. And there's further discussion. There's further discussion needed in terms of how those fit into this Oregon Housing Needs Analysis implementation program. Should the ONA implementation rely on those minimum standards? Should they rely on safe harbors and or emphasize local differentiation in this process? And so that's really the work of this Housing Actions Work Group over the course of 2025 to come back to the commission with those pathways on how to proceed there. And we're asking the commission today to amend the rulemaking charge to expand the work of the Housing Actions Work Group to consider those things, incorporate tools like safe harbors, incorporate things like minimum standards to to serve the purpose of enhancing housing production, affordability, and choice, and to achieve those fair housing outcomes that that are the core of Division 8 and the ONA program. So with that, Chair will entertain any questions or deliberation on the Housing Actions Work Group and the amendment to the rulemaking charge.
Do any of the commissioners have any questions on the amendment to the rulemaking charge? Commissioner Warren.
Can you just give us some examples of what we would be considering for safe harbors and minimum standards? Like just off the top of your head, what's been discussed?
Great question, Commissioner.
Chair Halva, Vice Chair Lazo, and Commissioner Warren, thank you so much for the question. As Ethan said, the reason why we're coming here for an amendment to the Rules Advisory Committee charge is because this question came up, or this discussion and this topic came up through discussion in 2024. And you might recall, I'll go back to an example that I can offer to you all that was an existing point of discussion that at one point in time was part of the draft rules, specifically thinking about safe harbor when it came to a housing type mix. And so in that housing type mix, it provided kind of require a delineation of what a local government might consider in that type mix. That would be an example of a safe harbor. And should a local government, and that safe harbor specifically was in the contextualized housing needs, so in the needs identification. Because that requirement of understanding housing types in the needs identification and the contextualized housing need is an obligation of the local government, this safe harbor type mix could be an option that a local government could take to obtain an output of a type mix in that particular work.
I'm going to ask a clarifying question because not everyone here is a planner. What is a type mix?
Anyone else on the answer? Share the mic.
Commissioner Warren, so that would be, a mix of low density housing, medium density housing, and high density housing. What is a percentage breakdown of a 100% amount of, the types, and 30% or 30% and 30 or 50, 60, those kind of, that would be a type mix safe harbor. So in Mari's example, a local government would be able to, in making that determination of their future type mix, could take the safe harbor approach and say, instead of doing all this analysis, I would like to use this safe harbor, and we are going to plan for 25% low density housing. I'm making up numbers, but you could use that as a pathway to move through the process. As an example.
And that's like a zoning lands for those percentages, or what does that mean for them? Or creating production strategies that manifest those?
Chair level both. Yes. Right. Okay. So because the contextualized, so Mari's example, we're talking about a safe harbor in the context of the needs identification. So in that first section, contextualized housing need, there's also an opportunity for local government to, or for this work group to consider safe harbors and minimum requirements in the action selection portion of this work in the housing production strategy program. And to your question, because the contextualized housing need, if we're talking about safe harbors in that portion of this work, and it serves both the housing capacity analysis and the housing production strategy as the informational basis for both. It would be, by that nature would inform things like zoning decisions. It would also inform things like housing production actions, housing production strategy actions.
That's a follow-up question to that. So let's say there was those two things that you just said, and then the outcome didn't produce the result that you see what I mean? And then they went into the housing accelerator program.
Chair Lova, I don't know, Thea, if you want to answer that question, but I think that's something to be determined, right? How all those pieces fit together. So there's one element of this housing actions work group, which is let's talk about those actual safe harbors and minimum requirements. But then there's also a portion of that work that's talking about, well, how does that fit into the program? And how do we follow that thread all the way through from beginning to end?
I was gonna I'm glad another person's on this, this rulemaking. Vice Chair.
Yeah, thank you, Chair, for your comment, because that's exactly right. And I think my comments will show how torn I am and how difficult a topic this is, frankly, right? One thing I will say, even that I think you started to touch on it here, but not only are safe harbors and minimum standards kind of this opportunity to set those standards like that, but they're also an opportunity to be a capacity resource for communities that, we talk about the flexibility, but that also means effort, right? And so you could put in minimum standards and safe harbors, and the community could choose to adopt those then and not have to do, as you said, I think where you started on, is not have to do the analysis to figure out what they are. That being said, somebody has to do the analysis to figure out what they are. And I think we just said here, I don't think the safe harbor, at least in my opinion, I don't know that a safe harbor is an outcomes-based piece. I don't know that we can hold a city accountable for saying the safe harbor is to produce 25% of low density, 30% of middle, and 45% multifamily. Right? Jurisdictions don't have that kind of control. And what I recognize, where this all comes from is having been intimately involved with that conversation around safe harbors in just one area of the rulemaking around housing types. And when you think about how complicated it is to do that from Eastern Oregon through the valley to the coast. And so where I'm headed is I'm just torn on the statement that's in front of us that commits us to some degree to safe harbors and to minimum standards. What I'll say is, I think what it commits us to is continuing that discussion, trying to understand what's best and what might work best, and then coming back when that group is ready to say, did we get it right? I think that's as much as they can commit us to, because I think it's intensely difficult. And I would hate to see us not only trap ourselves, but trap the communities that we're actually trying to serve because the language was written in a certain way. So I can live with the language, I think, as long as the understanding is that that's kind of where this is headed in the coming year. And that's what I would offer to my colleagues is my hope is that's what the understanding of the language is.
And I understood it that way. I also understand how hard it is. That's why I was made that comment. I understood it as a further exploration to see, can we do this? Because if there is and it doesn't have to be for all of it, it can be for some of it. Like, we don't know could we explore these two concepts, and we just don't know, is it going to be all or some, or a thread that goes through it. And so I felt like the charge was flexible enough that it is an exploration, but it's going to be interesting, I agree, to see what comes out of the process.
Can we put that back up on the screen, please?
I think it's the next slide.
Shayla, I don't know if I actually have the charge on
You have it.
the screen, but it is in it's attachment G. If you're looking at the whole packet, it's the last page of the packet.
Give me a couple minutes.
Yeah,
to get
keep
that.
scrolling.
Is it page 21? Is it on there? develop clear compliance pathways for local.
That's correct.
Yeah,
I
so it's
could-
on
I
page
could read it.
21 of 22.
I could read it into the mic if you'd like.
I'd like to just read through it again.
I
There
can,
it is.
I can, you want me to read it? Develop a clear compliance pathway for local governments through the housing production strategy and housing acceleration programs, utilizing program design tools like safe harbors or minimum standards in furtherance of affirmatively furthering fair housing, increased housing production, affordability, and choice, and reliability in program outcomes for local governments. Yeah.
Is like a strong or a soft enough word, in your opinion?
Which like, sorry. Oh, like safe harbors or minimum. Yeah. Yeah. I think it's good enough. I think there's been a lot of work that's been put into this paragraph. I'm not of an opinion to mess with it personally, but Commissioner Thompson.
Well, the phrase damned with faint praise comes to mind when we're considering this. When the liaison says, I don't know, maybe it'll work. Because all of this is such a gamble. We see the need. We're doing our best to develop strategies and put resources in people and stress people and cause consternation, because at the end, this is the best we know how to do to produce the outcomes.
And this is similar to, it's similar and not similar, let's just say, to when we were doing the middle housing. You know, it was like, hey, if you just want something off the shelf, here's this model code, adopt it. You've made your compliance. Or if you want more flexibility, right, you can choose your own adventure type thing. You can take the model code and change a little bit of it or change it all, as long as you meet these minimum, what do we call those? The
minimum compliance standards.
Minimum compliance standards, right? So it was the kind of the spectrum of, is it super flexible with minimum compliance standards, or is it just prescriptive? Do that. And so I think for this one, it's going to be interesting. Like, that's very clear. It's just like, you know, allow for these middle housing types, right? Just one singular thing. And so my thought is there going to be like one singular thing or two singular things or something that this works for within that rulemaking, or is it trying to be more comprehensive? That's what the Rules Advisory Committee is going to have to figure out.
Chair, a little bit if I could. Yeah, I would just kind of like to highlight that point about, I think this language here provides the opportunity to have those exact discussions as part of this housing actions work group and with the rulemaking advisory committee to, you know, continue that discussion, because it was part of the 2024 rulemaking space. And it just needs more time and dedication. And I think this language facilitates that conversation.
Commissioner Thompson.
I'm wondering how much taxpayer money we are devoting to this experiment. Because as I look at the risk benefit analysis, it seems to me it's a reasonable risk, but I wonder the cost to produce. I mean, we've got a pop in, but we're saying we want people to work to produce wealth that we're going to spend in responsible ways. We, in my mind, have a devotion to using public money well. And I just want to know how much public money we're talking about. That may be a question you can answer, I hope.
And it's my understanding this was already planned out to be doing work during this time. It's just adding this component to the same time frame. That's my
correct, Chair
understanding. So it's not a whole new exercise, I guess. It's fit into.
Nevertheless, for
existing
me,
exercise.
that's part of why I come here, is because I care about how money is spent for public benefit in the state of Oregon. And generally speaking, you know, I think we do a reasonably good job because we are devoted to the achievement of results, which is the reason we spend money. So this is a couple $100,000 for this committee? Is that it? But it's part of a larger, I just hope we keep cost benefit analysis and the fact that somebody has to work to earn that money that we are dispersing for good cause.
Chair Lova and Commissioner Thompson, you're in. it's a tricky situation. I don't know. I'm looking at my deputy director and director if they wanted to chime in, but you're in the ballpark, I guess is what I can say there. If yield the floor to
Deputy Director Green. Thank you. We did request additional funds for this, if I may, Chair Halova and Vice Chair Lazo. Commissioner Thompson, thanks for the question. We did ask for $350,000 additional to do this work, and we were granted it. We were able to move funds around to be able to support this work. So you're right, it has a cost, and thanks for the question.
So polite. I mean, I just love that. Thank you for the question, regardless of how challenging it is. I mean, it's really a very fun group to work with. Thank you.
And I think, the budget, the governor's recommended budget and the governor's priorities are housing, and so, and I'm not gonna say we never worked on housing before, but it wasn't really a topic. So we're in that mode, right? We're figuring out housing. So it seemed, whether this is what we should be doing or not, housing in general seems appropriate, I guess, for now. But yeah, I think the budget cycles that come with it, I guess, are supporting it. Vice Chair.
Thanks, Chair. The one thing I'll say also is that, what you were going to bring to us was not an extension, but a work plan for 2025 anyway, right? We knew coming out of the RAC that there's more work to be done. The question that I'm having around this is, again, what is the priorities? How does this target us? What does this lock us into, basically? And I feel okay about the language. I just think I wanted to make the point today that, we get down the line and say, here's what we're going to hold that piece accountable for when it comes back in front of us, right? That we want to make sure it's right and not just done.
Commissioner Warren.
And I just want to make sure that we're establishing very clear expectations for what we're asking of the RAC as part of this charge. Because the first word is develop, right? Which makes me nervous instantly. It's like, you're going to develop this. And then what is that thing? And it says programs utilizing program design tools like safe harbors or minimum standards. And because there's like in there, I'm okay with it because this is not a policy that we're going to have to, go into court over. But I just want to make sure we're all on the same page, that we're asking them to consider things like that to bring back for us to discuss further.
Great discussion. Okay. Does anybody want to make a motion around this charge?
Sure. Requests. I move the commission adopt the amendment to the Oregon Housing Needs Analysis rulemaking charge as recommended by the department and shown in attachment G of the staff report.
Second.
Okay, Commissioner Warren made the motion and Vice Chair Lazo seconded it. With that, Denise, can you do the roll call?
Commissioner Bennett,
Aye.
Commissioner Boyer,
Aye.
Commissioner Porter,
Aye.
Commissioner Thompson,
Aye.
Commissioner Warren,
Aye.
Vice Chair Lazo,
Aye.
Chair Halova.
Aye. And with that, the motion passes around the change to the rulemaking charge on ONA. Thank you. Thank you for your presentation. Okay, that concludes our last agenda item for today. I was actually, this is a very energizing meeting for me, to be honest. A lot of exciting topics to discuss. We're going to recess until tomorrow at 8 a.m., where we're going to begin with agenda item number 8, commission business. And yes, please make sure to fill out your scorecards with today's items when it's fresh in your mind. Thank you. Thank you, Commissioner Bennett. We'll see you tomorrow.